Private member's motion, the Honourable D.A. Feetham.
Yes, Mr. Speaker. It's 9:05, and somebody has just tweeted, I thought it's quite amusing, that we've gone from aquí no se pesca to aquí no se cena esta noche, Mr. Speaker. But, Mr. Speaker, I have the honour to move the motion standing in my name, which reads as follows. This House notes the findings of the report of the Dr. Giraldi Home Inquiry produced by the Inquiry Chairman, the Right Honourable Sir Jonathan Parker. The House particularly notes the following. 1. That all the allegations of abuse in the Dr. Giraldi home were properly investigated by the Social Services Agency as and when the allegations were made. 2. That those allegations of a criminal nature were referred to and investigated as appropriate by the Royal Gibraltar Police. 3. That there was no conspiracy by any government minister or indeed anyone else to prevent the allegations in the witness statements filed on behalf of Joanna Hernandez from being put into the public domain and or becoming the subject of judicial investigation, whether by delaying or obstructing the hearing of the claim or by stifling the claim, by prolonging the proceedings unnecessarily or by any means. 4. That the serious claims were untrue, grossly exaggerated or unsubstantiated by credible evidence. 5. That the staff at the Dr. Giraldi home were subjected to unfounded, offensive and regrettable criticism. This House is grateful to the care staff at the Dr. Giraldi home who, despite having been the victims of the most spurious allegations, stood steadfast in their resolve to provide the best possible care to residents and service users in very difficult circumstances. This House thanks and reaffirms its trust in the Royal Gibraltar Police, outgoing Attorney General Ricky Roda QC, and the Social Services Agency. This House resolves to repair the damage caused to the reputation and good standing of the Dr. Giraldi home, its staff, and the Royal Gibraltar Police, the Social Services Agency and the Attorney General by informing through a letter from the Leader of the House, the Spanish TV channel Antena 3 and the producers of the Espejo Público program of the outcome of the inquiry. Mr. Speaker, this motion concerns one of the most disgraceful and sad episodes in Gibraltar politics. An episode that involved the systematic and merciless exploitation of allegations by members opposite, which they were told on numerous occasions, Mr. Speaker, both in this House and outside it, had been investigated by Social Services Agency and the RGP and had been found to be without foundation, Mr. Speaker. Some of the most serious allegations, which, as they well knew, had also been considered by Her Majesty's Attorney General at the time and again found to be unsupported by credible evidence. I know, Mr. Speaker, that the honourable members opposite will say that at least they conducted a public inquiry. But the point is that the inquiry would not have been necessary had they chosen to accept the assurances of the Royal Gibraltar Police, the Social Services Agency, Her Majesty's Attorney General and the Chief Minister of the day that the allegations had been investigated and found to be without foundation. The stark reality is that the inquiry has been a cure for an illness that they themselves invented, Mr. Speaker, because if it had not been for the manner in which they turned Mrs. Joanna Hernandez into a cause celeb, it would not have been necessary to spend over £3 million of taxpayers' money on it. And the reason why the parties refused to accept the assurances of all those public authorities was because they wanted to exploit the allegations for their own narrow political ends with the intention of causing maximum damage to the government of the day, without care or thought, Mr. Speaker, about the collateral damage that it would and indeed did cause those institutions of state, such as the RGP, the Office of Her Majesty's Attorney General, and above all, the real victims in this sad episode, the staff at the Dr. Giraldi home. Mr. Speaker, members of staff that have stood steadfast and with great dignity in their resolve to provide the best possible care to residents and service users, whilst the parties opposite continued with their systematic and calculated political campaign, both in Gibraltar and abroad, against the Dr. Giraldi home. A word of mouth campaign, a campaign on social media, in the press, and on television, both here and in Spain, Mr. Speaker. Mr. Speaker, I do not understand, for the life of me, how the Chief Minister can in the future stand up in this House. Indeed, I don't understand how he stood up in this House today in the context of the last motion that we have debated, and with a straight face accuse anyone in the opposition of doing Gibraltar down with our legitimate criticisms of the public debt or their handling of the fishing dispute, when they were responsible for turning Mrs. Joana Hernandez, one of their political activists, and her unfounded allegations into a cause célèbre both here and in Spain. Mr. Speaker, and I am going to demonstrate today just how orchestrated that campaign was. On the 26th of April 2006, the Industrial Tribunal gave directions, Mr. Speaker, for steps that needed to be taken in Mrs. Hernandez's claim against the Social Services Agency. One of those directions was that witness statements be exchanged by the 16th of June 2006. At that directions hearing, Mrs. Hernandez was represented by the honourable gentleman opposite the Chief Minister, Mr. Picardo, who continued to act for Mrs. Hernandez at the time that witness statements which formed the basis of the allegations were being obtained. Witness statements, Mr. Speaker, that were prepared of all places at GSLP headquarters, not at Hassan's, at GSLP headquarters. I'm not inventing that, Mr. Speaker. It is admitted in a press release issued by the GSLP on the 26th of November 2009. It's in their press release. Those witness statements were then systematically leaked by someone, I don't know who, of course it must be a limited number of people, but it was leaked by someone to the Vox newspaper and printed verbatim by that newspaper on a weekly basis. A newspaper openly supportive, Mr. Speaker, of the parties opposite. Mr. Speaker, I have never come across in my 22 years of being a lawyer, and in the 15 years that I have been involved in politics, with a situation where all the witness statements produced in a particular case were leaked and printed systematically by a newspaper as part of an intensely orchestrated political campaign. Mr. Speaker, it gives me no pleasure to read some of the headlines and parts of the articles printed by the Vox. But I think it's important, Mr. Speaker, that those listening to this debate appreciate the intensity of the campaign and the vileness of the allegations made against the carers of the Dr. Giraldi home, to then appreciate the huge, entirely manufactured cloud that these poor carers had to endure, and the extent to which they were exonerated by the report from the Right Honourable Sir Jonathan Parker. Mr. Speaker, the first salvo came on the 16th of May 2008, issue 2775 of the Vox, under the front page headline, I quote, "Crime is crime, whatever Rhoda may say," end quote. The Vox then carried a story saying that, and I quote, "Written allegations by agency staff, which were handed to Ms. Joana Hernandez soon after she took up her post at the Dr. Giraldi home, along with other allegations which would have formed part of the Industrial Tribunal evidence, which the government attempted to suppress paint a damaging picture of abuses in the agency. Crime, however serious or trivial it may be, should not be merely brushed under the carpet because it would be politically embarrassing for action to be taken. End quote. The article, Mr. Speaker, was clearly intended to convey the imputation of criminal conduct in the allegations made against the carers at the Dr. Giraldi home, which were not, according to Mrs. Hernandez, and indeed an opposition press release contemporaneously issued at the same time, were not being investigated by the police or Her Majesty's Attorney General because they were being suppressed by the government of the day. And indeed, in that article, Mr. Speaker, the evidence in support came from those leaked witness statements in the Joanna Hernandez tribunal case. On the 21st of August 2008, issue 2787, under the front page headline, quote, "Agency covered up evidence of cruelty to child in care," end quote, the Vox carried an article again from one of the witness statements and stated, quote, "Protracted abuse of a child in care of social services agency over a 5-year period was never investigated by the agency. Though a doctor found bite marks on his arms, he had suffered unexplained fractured leg and then been punished by having his head held inside a refrigerator." And I'll come back to the allegation when we look at the conclusions of the report, end quote. At page 12, under the headline, "Significant abuse allegations were ignored," the article then set out the statement by the GSOP Liberal opposition at the time, which referred to various allegations of abuse as, quote, "having his head pushed into a fridge, given cold showers whilst the child was screaming as a result of his condition. This is not in fact an isolated incident, but a reflection of the culture that persisted in the way the agency has handled its responsibilities of those it is supposed to be protecting and caring for," end quote. Not an allegation by Joanna Hernandez, an allegation by the honourable members opposite when they were in opposition. On the 4th of September 2008, the Vox carried the front page headline in capitals, Dr. Giraldi home, sex romps exposed. Carers urged mock sex acts for their own amusement, affidavit alleges. The article then goes on to say that, quote, "Workers at the Dr. Giraldi home were encouraged those in their care to indulge in mock sexual activities for their own amusement," end quote. Again, Mr. Speaker, quoting from witness statements that had been leaked to that newspaper from the Joanna Hernandez case. On the 5th of January 2009, the Vox carried the front page headline, "Locked in the Dr. Giraldi home, boy forced," and I'm using a more polite term for the word used by the Vox, "to defecate on floor." See page 20. At page 20, under the headline in capitals, "Giraldi home boy was bullied by sadistic carers, but no action was taken by fellow carers," the article then says, quote, "Details of an alleged regime of sadistic bullying of a young boy by 2 of the carers at the Dr. Giraldi home more than a decade ago are contained in documents which the Caruana government has attempted to keep secret, which the Social Services Agency has declined to investigate, and which the Attorney General has refused to act on," end quote. Again, Mr. Speaker, the article prays in aid of witness statements that it said had been filed in the Joanna Hernandez case. On the 11th of February 2009, the front page of the Vox carried in capitals the headline, "The girl with burnt buttocks." See page 3. And then under page 3, it says, the headline, "The girl with the blistered buttocks, Giraldi home carers, sadistic and sexual pastimes disclosed in a dossier of shame." And then it says, an article referred to claims in respect of, quote, "a young girl who was in the care of Social Services Agency was brutally abused by the staff at Dr. Giraldi Home are contained in a dossier prepared by whistleblower Joana Hernandez, which she intends to release to the media in Britain and Spain, end quote. The article then describes how a girl was tortured, according to them, by making her sit on a bidet with very hot water until she sustained severe burns on her buttocks. And then it continues, the dossier also contains a string of allegations of drug misuse, of overdoses being given, and of drugs going missing, end quote. Yet another headline, Mr. Speaker, in the Vox newspaper, again from witness statements filed in the Joana Hernandez tribunal case, referred to allegations of sexual misconduct on a trip to Lourdes. The picture, Mr. Speaker, was of systematic abuse of the worst possible kind, coupled with a cover-up by the then Gibraltar government, the RGP, and the Attorney General. And it's a picture, Mr. Speaker, that they gave vent to when they were in opposition, Mr. Speaker, and indeed used it to their own political benefit, unashamedly so, for many years at that time. For example, Mr. Speaker, on the 29th of October 2008, press statement, GSLP press statement, 124 of 2008, the parties opposite said, quote, the reason why the opposition continues to make public the shortcomings at the Dr. Giraldi home is because both the Social Services Agency and the government have been involved in a cover-up exercise since the allegations came to light. End quote. And accepting, Mr. Speaker, the veracity, this is not a question of Joana Hernandez making these allegations and the opposition being at arm's length from Joana Hernandez. No, Mr. Speaker. And accepting the veracity of the allegations made by Mrs. Joana Hernandez, it appears without question, they then said, quote, Gibraltar owes a great debt of gratitude to the former manager of the home, Joana Hernandez, for having had the courage to come forward and make public what was happening at the home behind closed doors. End quote. Unequivocal, unconditional, a statement, Mr. Speaker. And then to conclude, the press statement also said this, quote, nobody has yet taken political responsibility for what happened in the past, when in other countries heads would have rolled for far less, end quote. Well, Mr. Speaker, what heads are going to roll now that we find that there was no basis for the allegations of either serious abuse or of any conspiracy or cover-up by the authorities of the then GSD government, Mr. Speaker? In any other jurisdictions, head would have certainly rolled, Mr. Speaker, for far less. Talking about rolling of heads, what heads are going to roll, Mr. Speaker, now that members of the benches opposite have been found, Mr. Speaker, to have spread unfounded allegations in the Spanish TV channel Antena 3, where as a consequence of those unfounded allegations, the Dr. Giraldi home was described as, quote, the House of Horrors, Mr. Speaker. What heads are going to roll for the participation of members of the benches opposite in that program? Mr. Speaker, Gibraltarian politicians participating in a program in Spain denigrating our institutions. It can't be described as anything else, Mr. Speaker. It is simply not credible to suggest that they didn't know that the Spanish TV channel would not be casting the worst possible light on Gibraltar and its institutions. If anyone on this side of the House, Mr. Speaker, had done anything remotely resembling that, our reputations would have been burnt to an absolute cinder by the GSLP machinery, Mr. Speaker. That is the reality. And I hope, Mr. Speaker, although I won't hold my breath, having heard what he said earlier in reply to what I said on his motion, that never again do members opposite preach about doing Gibraltar down with our own legitimate internal criticism, because they're not criticisms in Spain, they're here in Gibraltar, about the public debt and about anything else which are important issues of the day for this community. If we make the criticisms, Mr. Speaker, we make them here in Gibraltar. We do not go to Spanish TV channels doing our institutions down and doing our community down. That is something that they, to their eternal shame, did in relation to the Dr. Giraldi home. Not only, Mr. Speaker, have heads not rolled, but we haven't even had an apology from members opposite for that shameful intervention in that program. Not even an apology, Mr. Speaker. A sorry, an admission that they were wrong in doing so. Well, look, Mr. Speaker, when the honourable gentleman rightly said he hadn't made the North Korea comparison in the United Nations, I said, yes, I accept, I made a mistake. He made it in the BBC programme and in Sky News. But Mr. Speaker, it pales into insignificance if we're going to talk about comments doing Gibraltar down or comments misleading anybody. It pales into insignificance with the participation of members of this House on a Spanish TV program doing the institutions of this community, doing the carers of this community down, Mr. Speaker, because that is what they did. And not a squeak of an apology, Mr. Speaker, to this House for their participation in that program. Indeed, Mr. Speaker, at a time when the government is taking legal action against the ABC newspaper, rightly we've said, for the defamation of Gibraltar, it's incumbent on the Honourable the Chief Minister, the leader of this House, to correct one of the biggest defamations ever to have been perpetrated against Gibraltar, its workers and its institutions, which was a defamation that was aided and abetted by the Honourable Gentleman's opposite, Mr. Speaker. And at the very least, he ought to do what I suggest in my motion, which is to write to the producers of the program and informing them about the results of the investigation, correcting the record that they so cynically and incorrectly created in that program those years ago. Mr. Speaker, I have set out how the allegations contained in the witness statements were leaked to and published by the Vox newspaper. This is what Sir Jonathan Parker had to say about those allegations, and I quote directly from the report, Mr. Speaker. I think it's important that this House have a recitation of exactly what Sir Jonathan Parker has found in his conclusions in the report. Quote, regarding the alleged incident of sexual misconduct on the trip to Lourdes, you may recall the headline in the Vox, I am more than satisfied that no such incident in fact took place. As to the allegation that X and another carer put Z's head in a freezer and he shouted like an animal, I find no such incident occurred. As with the alleged head in the freezer incident, the evidence of X and Y in relation to resident Z being given cold showers, insofar as it suggests that this was a form of punishment meted out to resident Z, is also based on an unfounded rumour. As to Mrs. Joanna Hernandez's allegation that staff at the home did not give priority to caring for residents and the associated implications that service users were treated as silly little children or adult imbeciles, is a travesty of the truth and an insult to the efforts of dedicated members of staff. An insult to the efforts of dedicated members of staff. Her allegation that the home was in virtual chaos, that the entire culture at the home was one of institutionalized historic malpractice are also rejected. Experienced carers such as Sharon Barini and Sean Mato would not have allowed themselves to be associated with such a situation, nor would they have allowed any sexual, physical, verbal or emotional abuse of service users to take place in the home. As to Joanna Hernandez's allegation that Yvette de la Agua pressurized Isabella Tosso and or Mari Gomez into threatening her with losing her job and career, in oral evidence, Yvette de la Agua described that allegation as an outright lie. I accept Yvette de la Agua's evidence and find the allegation to be wholly without foundation. I accept Yvette de la Agua's evidence that she took her ministerial responsibilities in relation to the home extremely seriously and did all she could to discharge those responsibilities promptly and effectively. I accept without qualification the evidence of Yvette de la Agua, Jaime Neto and Sir Peter. I find that there was no conspiracy by anyone in government or indeed anyone else to prevent the allegations in the witness statements filed on behalf of Joanna Hernandez from being put into the public domain and or becoming the subject of judicial investigation, whether by delaying or obstructing the hearing of the claim, or by stifling the claim by prolonging the proceedings unnecessarily, or by any other means. And Mr. Speaker, I am still quoting from the conclusions. Quote again, many of the allegations in the witness statements filed on behalf of Joanna Hernandez in the Industrial Tribunal in 2006 were untrue, grossly exaggerated, or unsubstantiated by credible evidence. In any event, allegations of serious misconduct or abuse were investigated by the management, the Social Services Agency, and the relevant authorities, including the Royal Gibraltar Police, as the case may be. There was no conspiracy to prevent such allegations being investigated or being put into the public domain. The decisions taken by the relevant authorities, including the Royal Gibraltar Police, in relation to such allegations were justified. To the extent that such allegations were established on the evidence, the incidents in question were largely historic and infrequent and had been dealt with at the time by management at the home and the Social Services Agency. I find there is no factual basis for Joe Bosanos' suspicion that the government's motive in taking and pursuing the preliminary point was to prevent the allegations contained in the witness statements filed by Joanna Hernandez coming into the public domain, Mr. Speaker. As to whether improper pressure was applied to the Transport and General Workers Union in reaching its decision not to fund Joanna Hernandez's claim, no evidence has been presented to the inquiry to support Joe Bosanos' suspicion. I accordingly reject suggestion that improper pressure was exerted on the Transport and General Workers Union in connection with its decision not to fund the Joanna Hernandez claim in the Industrial Tribunal. Accordingly, I find Joe Bosanos' suspicion in relation to the conduct of the Industrial Tribunal proceedings by the government, Social Services Agency, to be unfounded in every respect. Pausing there, Mr. Speaker, how on earth do the honourable gentlemen opposite justify the call for heads to roll because of allegations made by Joanna Hernandez in 2009, and for no heads to roll now that everything that the Honourable the Father of the House said was absolutely proved to be false, to be wrong, to be false? I mean, there is not a Western democratic country in the world where something like this would have happened, where there would have been participation in a foreign TV program, where there would have been a campaign of the intensity of this campaign, for those people to get it so badly wrong, to go to a tribunal of inquiry to say there was a huge cover-up, and then for that tribunal of inquiry to find that there was no cover-up at all, and that his evidence wasn't accepted in any respect, And still he remains a government minister, Mr. Speaker. Because this is the time for heads to roll. Not in 2009, but now, Mr. Speaker. Accordingly, I find Joe Bossano's, again I quote, suspicions in relation to the conduct of the Industrial Tribunal proceedings and the Government Social Services Agency to be unfounded in every respect. I also accept the evidence of Superintendent Acris that the RGP was never instructed by anyone not to investigate cases of abuse, or indeed any other type of case. Lastly, I consider the decision of the Attorney General not to institute criminal proceedings against the three carers to have been fully justified, if not inevitable, given the quality of the available evidence. End quote. There can be absolutely no doubt at all, Mr. Speaker, that Sir Jonathan's findings are a complete vindication of the staff of the Dr. Giraldi home, which were vilified in those years of intense political campaign, aided and abetted, Mr. Speaker, both here in Gibraltar and in Spain by members opposite, Mr. Speaker, and indeed, I have to say, proudly, Mr. Speaker, of my government, the GSD government at the time, Mr. Speaker. And Mr. Speaker, I want to place on record my admiration for the dignified way in which my colleagues at the time, Yvette de Laura in particular, but also including Jaime Neto, acted in the face of dreadful allegations of cover-ups, of abuse, aided again and abetted by members opposite. As parents of children, Mr. Speaker, if nothing else, and indeed people that take their jobs very seriously, I know that my friend Mr. Neto and Yvette de Laura have always done, it could not have been easy for them to have served in a government with that type of intense political campaign, week in, week out, by the Vox newspaper, by one of their activists, Mrs. Joana Hernandez, and by the parties opposite. There is nothing, Mr. Speaker, in this motion that is untrue or unsupported by the conclusions of Jonathan Parker. And Mr. Speaker, for all those reasons, I commend the motion to the House.
I now propose the question in the terms of the motion moved by the Honourable D.A. Feetham. Honourable Mr. Bossano.
For the avoidance of doubt, I am not about to either apologize or resign for the benefit of the Leader of the Opposition. Mr. Speaker, what is taking place today here is indeed what the Honourable Member is accusing us of having done. The report, let me point out, states that the recommendations are required, that no recommendations are required as to what should happen next from the inquiry, and that it is for the government to take any action that it deems appropriate. In effect, there are two options open. One is to consider the issue of the allegations dealt with and leave matters there, or what the motion before the House in effect is asking, which is that that should not be so. What it is trying to do is to say that the inquiry has concluded that everything was almost perfect, that no one did anything ever that should not have been done, and that the previous years the government acted correctly at the time and were always right. And if the motion was not intended to do that, the speech in support of the motion has. I, for one, reject outright that this is the truth. But I agree with the view that perhaps things should not be left as they stand, because I do not accept that following the evidence that has been uncovered in government documents, on discovery of those documents by the inquiry, such evidence inevitably gives rise to only one possible interpretation, namely the self-serving interpretation of the text brought to the House by the member opposite. To use their terminology, the opposition is now trying to milk this issue to gain political benefit from it. This has nothing to do with the carers, and even less does it have anything to do with the victims of the alleged abuse. The papers that have been produced for the inquiry reveals that, contrary to the public statements from the government of how well everything was, the home in the home, when asked in Parliament privately, the reality was very different. If we start, Mr. Speaker, by looking at what the honourable member is so concerned about with his Speo Público, he has today repeated what he has said before when I've told him it's not true. Nobody went to any program in Spain. A Spanish journalist came to my office and asked me what did I think of the allegations that were being made. And this is what I answered. 3 lines. And this is what came out in the program. Yo le pregunto en el Parlamento, bueno, si todo es un montaje, as he claims, y todo es mentira, entonces ¿por qué no se permitió que se escuchara el caso el primer día en el 2006? No lo han hecho y no lo aclaran. And that is still the accusation against the honourable members. If it was all false, if they had no problem with the witness statements, then why did they go through the lens that they did to prevent the hearing from taking place? Whatever the chairman of the inquiry may think or not think, that situation was created by them by not doing the correct thing, when not just us, but many other people were saying, have an independent, open investigation and clear the issues. They refused to do it. And if he's worried about the Speo Público, let me tell him that one of the carers, I don't know who it was, calling himself Mikey, wrote extensively on the area of that program, on the internet, and called everybody else everything under the sun. Presumably he's exempt from any question of putting things in the Spanish media, although I am no longer permitted by the criteria of the opposition to give an interview to a visiting Spanish journalist and tell him not that there are allegations, not that there is evidence, but that I keep on asking, if you say that it's not true, and if you say that it's all a made-up job, then why don't you put your money where the door is and allow an open-ended inquiry without having to wait for the tribunal to take place? Indeed, everything that they did was in the opposite direction. The Social Services Act requires the immediate investigation of allegations without delay. There is no evidence that the board of the social services has ever had a report or record of anything having been investigated. Ever. There was nothing there when we got in. The ministerial response to the issues that I have brought in the House in the past have been, for the member opposite, so highly praised by the leader of the opposition, to tell me that he never heard of the issues that I was raising. Indeed, I remind the honourable member of question 857 of 2008. Wasn't about the Giraldi home, but it is relevant to show the degree of involvement and knowledge of ministers. When I pointed out to the honourable member that there was an 11-year-old child in the KG5, The reaction of the honourable member was, it was after lunch, and I said to him, so is it then that the concern that has been expressed while the child was in KG5 to approaches being made to him by people who were really mentally ill, which the child was not, when he was having his 11th birthday, is that something that he doesn't know anything about? And what did the honourable member say? This very concerned minister who's on the top of the job. I do not know what on earth the leader of opposition is talking about. But look, it is not for me as Minister for Social Services to go every single day to see how the management of the KG5 deal with it. I think it is absurd what the leader of the opposition has said. And Yvette Del Agua then stepped in and said, can I just add something to that? I think she was asking my permission, so I said yes. What the honourable member is insinuating, she says, is to my mind quite serious. He is only insinuating it, but it could lead to whoever is listening to believe that terrible things have happened to this child on his 11th birthday. Well, he was in the care of the KG5. I suggest that the person who passed the information on to him write to the chief executive. And I told her, well, look, it's not my job to go telling people to write, and in any case, when they do, you bin the stuff that they sent you, which she said was not correct. I pointed out that every time somebody made an allegation, a complaint, or an accusation, the result was that they were a disgruntled employee, a disaffected person, somebody that had lost their jobs, or somebody that had a grudge. Everybody was wrong. But there was never anything that was going wrong in the wonderful service that put a 10-year-old child in a mental home with adults, when there was written advice that the place was not suitable. When I said that, the honourable member opposite, that is so caring, I'm not sure whether he was already a philosopher by then, he might not have been. He said, I do not know what on earth the leader of the opposition must have had at lunchtime, but he seems to have gone absolutely bonkers in terms of the allegation. Bonkers? All I was saying is, what on earth has happened to the leader of the opposition when he went for lunch today? Well, Mr. Speaker, I told him he could call me bonkers as many times as he wanted. He says, I was making all sorts of wild allegations, totally groundless, baseless, and he didn't know for what particular reason. This is the kind of language we've heard from the leader of the opposition today. It didn't require Parker to spark it. It was already there in 2008. And I told him that he knew or should know what was going on, which he denied. Well, Mr. Speaker, let me just refer to the exchanges that went on between Chris Wilson and McCutcheon about the child in the KG5. Exchanges which Chris Wilson was saying he was briefing.
May I ask the Honourable Minister to link up somehow the question of the KG5 with the Dr. Giraldi home? I'm sure he's coming, he must be developing an argument, I hope he is developing an argument which will indicate the relevance of that to the Dr. Giraldi home.
The report in the Spanish media, to which the honourable member refers in the motion, talks about this particular case. Mr. Speaker, the exchanges that took place, which were copied to the Minister Yvette Del Agua, and which were also brought to the attention of the member opposite when he was telling me I was bonkers, told him exactly what I was making him aware of. that this child should not have been there, that this child had been put in a situation where he was at risk, that this child had been molested, and this was not allegations made by disgruntled employees. These were allegations made by the professionals in their employment. And when I brought it to the members' attention, what did he do about it? Instead of saying, well, look, if that is the information that you've got, which he had as well, but he seems to have forgotten about, then I will look into it. No. What he did was, you know, if you don't like what you hear, you shoot the messenger. But of course, what I had then and what I have now before me is what he knows is the truth. August 2007. There needs to be an immediate government response to the situation. I appreciate your commitment to this matter with your minister, but I fear a protracted period before appropriate decisions are taken. I told him that the professionals in the health service had a problem, that this child was sectioned when he was not mentally ill, that the assessment that had been made with him was one that he had a conduct disorder, which the psychologist said in lay members' terms meant that the child was naughty. And because he was naughty, they stuck him in KG5 for a month, and the agency was resisting him being released. And the child was sending people messages saying, help, get me out of here. And that, which was happening then, was the fault of the agency, or the fault of the hospital, or the fault of somebody, but nobody was prepared to take and assume political responsibility. Anywhere else in the world, the honorable member says about people having to resign. Anywhere else in the world, if you put an 11-year-old child and they find him with a naked, mentally ill patient in the shower, they're asked to resign. In the United Kingdom, Mr. Speaker, they are going back 40 years and 50 years and reopening cases. But here, no. Here, if you complain about something, if you say, I believe that this should be investigated, which is what happened. What happened was that some people were making allegations and other people were saying the allegations should be investigated and be seen to be investigated, and it should be open and transparent and independent. The issues that were there were allowed to grow and fester because the position of the government was a position which can only be described as the ministers responsible portraying the proverbial wisdom of the three apes that see no evil, hear no evil, and speak no evil. But there was no wisdom in their case. And that is not the only issue on which we see reflected the reality being one thing and what has been portrayed here today and throughout this period of time by the government of saying, sweep it under the carpet, there is nothing wrong, you're just milking this for political advantage. What political advantage can there be in wanting to get to the truth? What political advantage is there if instead of accusing you, Mr. Speaker, I ask that the accusation should be investigated and demonstrated to be true or not? And it would have been possible to do it very simply, very cheaply, and immediately had the tribunal been allowed to proceed. Because then the persons making statements would have been in the tribunal subject to cross-examination, and the truth or otherwise would have been cleared up. And the people denying the allegations would have been subjected to cross-examination. And then we would have known what was true. But that opportunity didn't happen. And it didn't happen because the government didn't want it to happen. And therefore, the reality of it is that we have today a situation where the members opposite feel that they can cry victory because A, of the time that has passed when nothing was investigated, and because at the end of the day, what we have is a report that does not say what the honourable member claims it says. The honourable member has chosen to selectively present that report in the way that suits his own political ends. In dealing with the issues, the tribunal has looked at a number of cases. And when we look at those cases, the inquiry may feel that the evidence that is available to them is not sufficient to persuade the chairman, who decides whose evidence he believes and who he doesn't believe. But what we have is a situation where this was not Joanna Hernandez being on a campaign and making allegations left, right and center on her own. Or is it that the honourable member opposite has forgotten that there was a letter before the period which stated, I was the former team leader in the Giraldi home until I resigned from the post in 2004. This letter, I suppose it must be a disgruntled employee, because that is the definition of everybody that claims there's something wrong, was by Duncan Jones, BA Hons, MSc, Diploma in Law, and Certificate in Management. This is not somebody who doesn't know what he's talking about. He was there in the home, and he says the government is lying when they say that things were being investigated. Because I left in disgust, because I did not enter a care profession to set aside the rights and well-beings of service users and others working in the care sector. My position was untenable and I resigned because full and proper investigation of serious allegations were prevented, thus placing both the staff and the service user at potential risk that were being disregarded. Was this drafted in the GSLP headquarters in 2004? There was no issue in 2004. This was the position that was inherited when there was a change that took place. And when that change took place, is it not the case that there was a letter from the minister to the chief minister saying that after the resignation of some people, the management in the home was completely out of control, and she was having to micromanage all the time and run it in 2004 and 2005. And after Douglas Rodriguez, and she was saying we need to put somebody here, and it was following that in 2005 there was an appointment of Joanna Hernandez that applied from within the civil service, where she was working in the education department. So the position in 2004, according to the manager that was in 2004, was not what is being claimed today in this house. And the position by Yvette Delagua in 2005 was that the position she had there was one that it was out of control and she had to micromanage. And the letter to do that is in the evidence before the tribunal. That's how we found out, because we don't have access to the letters that were going on before. So the tribunal evidence is not just producing things that suit them, it's also producing things that we would never have known but for the inquiry. And now that we know them, we have to take stock of them, given that we've decided that this is not going to be something that is going to end with the tribunal, because that is not what the honourable members opposite are seeking. They're not asking us to say, well, look, let's put this matter to bed. So they don't want to put it to bed. Well, look, I am game to carry on with this one. Yeah. And we'll see where it ends. And of course, the honourable member knows that that was not the only individual working in the home that expressed concerns, because there was a Mr. Harris that produced a witness statement for the tribunal, a witness statement which, of course, was not fabricated by anybody, because it's in his own handwriting, and the witness statements of the other people willing to say things under oath, because what the honourable member is saying is that a number of people, for no apparent reason, wanted to go into a tribunal and commit perjury. That's what they wanted. And here we've got a situation where all these people, for no gain and no benefit, express concerns when there's nothing in it for them. Well, I don't know how you judge the credibility of one person or another, but I would say that the balance of probability would be a good yardstick. And I would say that if someone has nothing to gain by saying that something is black and somebody has got a lot to lose, then you would expect the guy that's got a lot to lose to say that it's not black, that it's white. The people who put the statements in good faith. The concept of protecting people who whistleblow, in case the honourable member is not familiar with the legislation that has been there in the UK since 1998, is that whistleblowers are entitled to be protected even if they are mistaken, as long as they are doing it because they believe it to be true, and it's reasonable to see from the circumstances that that belief is tenable. You don't punish a whistleblower because it happens to be the case that he thought there was something going wrong and asked to be investigated, and then it turns out that it wasn't going wrong. He got it, that he was mistaken in a genuine belief. What a whistleblower has got no protection for is when it can be demonstrated that it is a deliberate misrepresentation because the person doing the whistleblowing has something to gain. The people who made the witness statements, all of which the honourable member are saying are fabrications, were people who stood to gain nothing at all. Of course, the Harris letter actually makes an allegation which refers to one of the cases before the tribunal and mentions that that person he witnessed. He doesn't say, this is not third party, this is not hearsay, this man is saying, I witnessed this particular child being treated in a way which was completely unacceptable. This is before the agency. This is at the time of Bilberry. This is in 1997. So why should somebody come out and say this years after he's left if he was not telling the truth? What was in it for him? Why should he want to do this? Well, of course, the honourable member is familiar with this case, because that is the case which helped him and his brother close down the box, which they must have been wanting to do for a very long time, given everything that he's read about the box. They must have been gunning for it, and this gave them an opportunity. Of course, the box has supported every political party in Gibraltar. Let's be clear. It supported the Gibraltar Labour Party. He used to write anonymous articles in it when he was in my executive. Well, let's put it that way. Circumstantial evidence, the circumstantial evidence is that there were articles that reflected debates in the executive that appeared in the box under an anonymous name, and they appeared when he joined the executive and stopped appearing when he left. Now, I'm not saying he was the one who did it. All I am saying that two periods coincided. Just in case I get accused of making false accusations. Right? So, at that time, the Vox was not such a bad vehicle. And of course, for very many years, I am sure the backbencher must remember that before he fell out with the late Mr. Campello, I was the target of Vox's campaign for many, many years. That is when they were getting adverts. The reason, of course, why the honourable member took action against the Vox was because what the Vox, what Harris claimed and the Vox apparently published. I didn't take any action. No, well, no, you were the Minister for Justice, yes, yes, of course, you were the Minister for Justice, and I think there might have been a possibility that the honourable member's brother, who dealt with the case, talked about it with his brother, but not with the Minister for Justice. Okay. The statement says, I told MF that he should not treat Ruben like that. And because the Vox said MF is related to a minister in the government, the position was taken that it could only mean one person. And that is what eventually the honourable member opposite took, or rather, the person that was named as MF, who might as well also have been Mikey in the Espejo, possibly, took action on the basis of this, and Mr. Harris was nearly polished off as a consequence of the papers that were served on him. He finished up in hospital, and the Vox collapsed, and the legal action that they threatened to take was sufficient to put them out of action. And one of our institutions, which has been at many occasions in its long history either friend or foe of almost everybody that has been in this parliament, ceased to exist. And that is part also of the history of what has been going on. So you see, the animosity towards the Vox is not driven by being on this pillar of height of purity and altruism. There are other factors involved. There are other interests and other connections. There is another case which happened, Mr. Speaker, in 2005, where the families of one inmate of the home, of one resident of the home, complained, but not to John Hernandez, because she wasn't there yet. They complained to another one of the people there, who put the complaint in writing, and this complaint was the case of this child being made to stand up holding books in his hands and being forced to have cold showers. And that complaint was not a fabricated complaint in the GSLP for the purpose, no, none of that. This complaint was put in the agency, to the management of the agency. It is on record, and we've only found that out because there has been discovery in the inquiry. So now we've got the papers that shows that, contrary to the picture that's being painted today, there were things going on before anybody arrived there, and when the person that was recruited arrived there, the first case that came up was a case in December 2004, which is the case that the police said they investigated in January 2005. And when, in the course of the inquiry, Commissioner Wink is asked about the investigation, in one of the occasions, he accepts that when he said publicly that the allegations had been fully investigated in 2005, what he was referring to was the allegation investigated in January 2005 of what had happened in 2004. But this was before the position arose in June 2005, when there was a number of allegations given to the manager, and what the manager did, which was so wrong, was that the manager took it to the CEO and said, look, I've got these allegations, and my advice to you is that you should suspend the people and have it investigated. That was not accusing anybody of being guilty of anything. The inquiry has been told falsely that she asked for them to be resigned. There is no evidence that she asked for anybody to be sacked. The inquiry was told something that was not true. That she said they should be sacked, which was not true, and the evidence is in writing that that is not what was asked for. What was asked for, and the position taken by Isabel Atoso on receiving that, was that the procedure that had been followed to obtain those statements was one that was incorrect and not in accordance with the rules of the agency, and that therefore she was not prepared to investigate. And she says in the letter that she sent that for this reason she was addressing the process and not the content. Well, maybe that is how they did things in the agency. I don't know. I would have thought if somebody says there is an allegation by a carer that another carer has treated a person in our home badly, and the manager says, yes, but I am not prepared to investigate this because the statement that you brought me was not brought according to the procedure laid down, and the person that you're complaining of wasn't told that there was going to be a complaint being made. I would have thought, I don't know whether these procedures are the best way to go about it, but I would have thought that if somebody were to bring me a statement in which somebody is putting their name down and saying that somebody has done something at work that they should not be doing, in effect whistleblowing, I would have said, well, look, you shouldn't have allowed this to be done in this way, because that is not the correct procedure. But whether the procedure is right or wrong, now that the statement has been made, we have to deal with it. That would seem to me a more rational in which you don't say, well, look, somebody's been murdered in the room next door, but I didn't do the right procedure when I opened the door. I didn't knock, so I've gone in and I found the body and say, well, the body's been there, the procedure's not been followed, sorry, we leave the body there. No, you deal with the situation that you find, even if the procedure is not the ideal procedure or the wrong procedure. Unless, of course, what you're saying, as has been said here, and has been said previously, is that people were actually threatened to make statements. Well, look, this is, in my judgment, a nonsense. This is a complete nonsense. How can there be any credibility in the idea that you threaten somebody to make a statement, and that what that statement is going to do is be put in the hands of the management, who are going to call in the threatened person and question them? Well, what's to stop the threatened person saying, no, what I've said is not true? Somebody's forced me to do it. I mean, what power can somebody have? The people that can threaten are the people who are right at the very top, not somebody that is in middle management earning 20 grand a year. If it was a person on the top, then you could be scared. Look, I don't know whether the ministers were fully aware of this or not. But I was told that this collection of statements was in fact copied to the minister and was copied to the then chief minister, because when they were taken to the union by the person that collected them, the union advised that copies should be sent to the relevant ministers so that they would know that this was happening. Well, I don't know, and I haven't seen anything that shows that they were or they weren't, and I don't know whether that has been admitted or denied. But I would have thought that when the honourable member talks about heads rolling and people standing, that the normal thing for a minister to do is that if somebody tells you in your department that something is going wrong, you check just in case it's true. I know that perhaps it's too much to ask, because if a member of the opposition tells you across the floor of the parliament that things are going wrong, you tell him that he must have got indigestion with what he had for lunch and that is bonkers, then that is not, you know, if that is what they tell the opposition, then I don't know what they tell their employees. So, of course, if the people that are politically answerable don't want to hear this, or don't want other people to hear it, then there is some rationale in what otherwise appears to be an unexplainable resistance to looking into these things. It was only a long time after, in the many sessions we had in this house, when having first said, when the honourable member opposite was minister, having first said that it was not investigated because the procedure was wrong, having first said that and maintained that for a number of meetings, they then changed and they said, notwithstanding that the procedure was wrong, it was investigated. But was it investigated? What was investigated? The statements in the inquiry don't talk about anything being investigated. They talk about a team of social workers being sent to different flats to see what could be done to improve the management. They didn't say somebody came along and looked at each statement and checked whether there was any evidence to substantiate those allegations. That was not done. And that is what an investigation means. And that was not done because the evidence before the inquiry produced by the people that were in the department at the time, Isabella Toso told social workers, go to those flats and see what can be done to improve the way they're managing things in there, which is fine. But of course, there wasn't even a need to do that. Because if that was saying, go in there and see what needs to be proved as a result of the allegations, then that's giving credence to the allegation. If the allegation was a complete fabrication, you don't need to send anybody in there to put things right. So either there was no investigation because they looked at the allegations and they said, yes, this seems to me to be true and something is wrong and I want to send the social workers there to put it right and forget doing anything else. Or, in fact, the exercise of going into those flats had nothing at all to do with the allegations that were made and the statements that were produced. It's something that was being done for management reasons independent of those. And therefore, when Parliament was told by the member opposite that the investigation had taken place subsequently by the social workers, he was misleading the Parliament because it was not an investigation that took place. Because an investigation means getting a piece of paper, looking at the allegations, calling people in and trying to get to the truth. And nobody was. Nobody was called in. Neither the people who made the allegations, nor the people against whom they were made. The June statement were provided to Isabella Tosso, as I've said. But of course, Isabella Tosso herself has, in the context of another case, made very clear that she did not support a decision that was taken not to proceed with disciplinary hearing. Now, how is it that when it suits the government, the decision is taken at that level, and when it doesn't suit the government, the management is then told what they need to do? Well, look, if the government felt that they could go and tell Isabella Tosso what was best by telling her when not to proceed with disciplining people, then clearly they had the power to do something about it when initially this situation arose, and deal with it. And if in fact it is so simple and so straightforward that everything that was being said was being made up by the people that were working there, which I do not believe, for the very simple reason, Mr. Speaker, that they make the same accusation and the same claim about the subsequent statements made, which I know not to be true, because I happen to be the person that was involved in those witness statements, and not, as a leader of the opposition has said, my friend and colleague Fabian Picardo. The statements in the GSLP, which he thinks it terrible, in the office of a political party, there were statements, witness statement being taken. If it's a lawyer's office, it's all right, of course. I mean, how can we dare to ask mere mortals who are not lawyers that we can actually take statements from people? Of course, the only difference is we don't pay. We don't get paid for the statements. We do these things free of charge. So there must be something wrong with us. But we can go to a lawyer's office, and the guy there sits down and writes what you tell him and charges you 200 quid for an hour's work. And that is perfectly all right, and the legal system is very happy with that. Of course, it's a closed shop. Of course you're happy. But what happens is that when people don't pay, then the clients are sent to people like me who do it for nothing. Because the reality of it is that the only reason why it finished in my hands was because the union decided to stop paying. Otherwise, I would not have been involved at all. So let's be clear that this was not an agenda driven by the GSLP in order to find something to attack the government, as if there were not 1,000 other things that we could attack the government on. We didn't pick this battleground. The battleground arose because the government failed to do what they should have done and behave as they should have done. In the statements that have been made by the report on the inquiry, it is not the case, Mr. Speaker, that it is as clear-cut as the honourable member would have us believe. It's clear-cut about me, but I don't expect Chairman Parker, who is not Chairman Mao, to say anything good about me, given that the last time we met was when the honourable member, the backbencher, was trying to get rid of Schofield, and he came to do the hatchet job, and I was there on Schofield's side. I went to speak on behalf of so you know, and the fact that Chief Justice Schofield, on top of it, I suppose, to make even matters worse, on top of it, actually said we were right when the appeal on the tribunal was said, must have also helped Chairman Parker to see things in a particular light. But we will see. This is not yet over. One of the things that is almost incomprehensible is that we've got one particular case, which I'm going to mention as an example. I think it's T. And this is a lady in the home that makes an allegations of sexual abuse. And this is a lady that Dr. Galloway says is quite capable of being cogent, and there's a letter saying that she knows, she's capable of what she's capable of saying is something that you cannot say this person is suffering from a disability that makes it impossible for this person to express themselves, right? The psychologists employed by the honorable member opposite produced reports of this lady. I brought that to his attention in one of my questions many years ago, and he said he didn't know anything about it. This was done in 2005, in March 2005. This lady writes a witness statement to the inquiry which almost repeats exactly what she said 10 years ago. The people mentioned in her statement are the same people that were mentioned 10 years ago. The chairman concludes that he believes the denial of the people involved. The people involved, I am not in a position to say what happened or what didn't happen because I don't know. But I am in a position, as much as anybody else, of reading what has been said and making my judgment of the judgment of the person that said it. And what the person that looked at this case said, well, yes, the psychological report supports the allegation, that's true. The Attorney General said that he tended to believe that it was true, but that regrettably, he had decided that he didn't think it was possible to get a conviction, and that therefore there's no point in starting a case, right? Dr. Galloway says that this person knows what she's talking about. Anybody, even a layman, would think that, for somebody to be saying that this happened to her 10 years later is because the trauma of what happened to her is there and it's still alive, even though that person, we all know that regrettably people with disabilities tend to age quicker than those that haven't got them, and this lady is now 10 years older, and therefore, but the evidence of the professionals are in support of what she says. But the conclusion is that it's not even a question. He says he agrees with the decision of the Attorney General that they should not prosecute because the level of evidence is not sufficient to get a prosecution. But he goes further. He says he doesn't believe it happened. He concludes that she may believe it happened because she lives in a world which is unreal for the rest of us, but it's her real world. And the reason why he believes that is because, having heard the evidence of the 3 persons who are alleged to have done this by this lady, this is not, now we're not talking with hearsay, we're not talking somebody saying I was told. So this is the victim saying this is what happened to me. It's the only victim that has actually put something in front of the tribunal, of the inquiry, the only one. And then, when the chairman writes the report, he says, having listened to the denial of the alleged perpetrators of this offense, I am convinced that it will not be in character for them to have done it. I don't know what they teach lawyers nowadays or what they teach judges, but I would say that if you can listen to 3 total strangers for half an hour each and conclude that you know them so well that you can say it's impossible because of their character for them to have done this 10 years ago. Well, look, you're in the wrong profession. You should be a psychiatrist. If just by looking at somebody you can say what their character is and what they can do or what they're not likely to be doing. And that is the evidence upon which there is a conclusion that the three people that are alleged to have committed an offense did not commit it, that the psychologists have got it wrong, that the lady that claims she remembers it happening has got it wrong, and that the Attorney General who said, I believe her, but I haven't proceeded because I couldn't get a conviction. Well, look, if you cannot get a conviction, then there's no point in going to court if you're going to lose it. I understand that. But I don't think that it is enough to persuade me that because you have listened to somebody for half an hour and he's made a good impression on you, you think it's impossible for this guy to be a character or to have a character that would do this. Look, Mr. Speaker, the world is full of serial killers whose character would appear to be impeccable if you met them for half an hour. If it was possible to spot killers or conmen on sight, they would all be in jail. They wouldn't be roaming. And that is the quality of the judgment that we have reflected. Well, okay, if we're going to go into a debate about this, if what you want is apologies, if what you want is, no, what you want then must be the truth. And this is, no, the truth according to you that suits you, no, the truth, the whole truth and nothing but the truth, whoever it suits. Because nothing, Mr. Speaker, we have nothing to gain or lose. We have stood by a principle that there are people saying things are wrong and that those people have got a right which no government should deny them, for them to be told, okay, I'll give you the benefit of the doubt, you say that's wrong, let's look into this and let's do it openly and let's do it transparently. And if you don't do it, then you can only blame yourself if people think that you're not doing it because you've got something to hide. So I'm afraid that the honourable member has made a serious mistake in bringing this here and in thinking that this is something that is going to let him walk out of this chamber saying we were right all the time and the other side have been wrong all the time. And Mr. Speaker, if I give you one final example of the quality of the assessments that have been made, one of the things that happened when Isabella Tosso disappeared was that they had somebody else coming in as manager, Ian McNeil, and in the stages of when the tribunal appeared to be finally going to happen, which it didn't, given that there was supposed to be evidence, which of course did not exist, that the problem was lack of management skills, and that was what created the dismissal. They produced a new witness statement made by Ian McNeil, and they presented as evidence in the Industrial Tribunal the business plan for Dr. Giraldi Residential Services, prepared by Ian McNeil and Sharon Berini in 2006, when it looked as if the tribunal was finally going to meet. And this has also been given to Chairman Parker. And he's very impressed with it. He's so impressed that he says it's the most wonderful piece, it's in the report, the members can read it, the most wonderful piece of plan that he's ever seen. that it guarantees the future running of the home problem-free, that is never seen such expertise displayed. Well, when this was produced, I first noticed that the font of Dr. Giraldi was different from the font of the rest of the document. And then when I looked at the back, I read that this is Crown copyright in the United Kingdom. And then I realized that this wonderful job is a download, copy-paste from the Department of Health. And that they haven't even bothered to remove the references to all the things that exist in UK, which don't exist in Gibraltar. Well, the quality of the ability to make judgments is reflected in that this is perceived by the inquiry report to be the most fantastic job produced by Ian McNeill and Sharon Berini. Sharon Berini, after this fantastic job, left 1 month later. And Ian McNeill left 2 years later, and nothing was done about the famous business plan. So the inquiry hasn't even bothered to do its own work in finding that this was produced for the tribunal and no further use was made of it. And therefore, if we're going to be looking in detail at this report, then we're going to look at every full stop, comma, and paragraph. Thank you, Mr. Speaker.
Does anybody else wish to contribute to the debate?
I mean, usually the sides alternate, but if nobody else is going to speak on that side, then I'm ready to speak. In that case, I'm quite happy to alternate with the honourable member.
The Honourable Mr. Neto.
Thanks, Mr. Speaker. Mr. Speaker, in my budget address of 2008, I said that the last 6 months, in particular, that is before the budget, that the GSLP and the GSLP-friendly media outlets had conducted a relentless and scurrilous campaign, primarily against my honourable friend, Mrs. Yvette Delauwa, and by extension to the GSD government, by using the Dr. Giraldi home as a political tool. In that speech, I went out to state that such an orchestrated campaign by the then opposition was nothing more than a political circus which not only manipulated the facts, but also had the effects of tarnishing the reputation and good work of the staff at the home and causing unnecessary anxiety to both the staff and the relatives of the residents of the home. Once again then, as I had done previously, and as I was to do again after that budget session, I said categorically that the allegations made by the then opposition had all been investigated by the then Social Services Agency, and that according to circumstances of each case, members of the staff had either been dismissed, reprimanded, within the disciplinary code of the then Social Services Agency, or such allegation dismissed because they were found to be untrue or unsupported by evidence. It is comforting to note the statement made by the Right Honourable Sir Jonathan Parker QC, where he did acknowledge that all allegations were investigated and action taken in one form or another, taking account of specific circumstances of each case. It is also comforting to note that Sir Jonathan accepted the evidence to the inquiry by Sir Peter Caruana QC. This is important because of the campaign by the GSLP and their friendly media outlets to portray the idea that he had used his political position as Chief Minister to suppress the allegations or in giving instructions to the RGP or the Attorney General as to how such institutions should deal with such allegations. The facts remain that Sir Jonathan did not find any shred of evidence to suggest that such interference by the then GSD government had taken place. It is also comforting to hear that the Right Honourable Judge say that he accepted without qualification the evidence of Yvette Delauwa, Sir Peter Caruana and myself, something that contrast vividly with his opinion of the credibility of the Honourable Father of the House, the Honourable Joe Bossano, when he says that Mr. Bossano's suspicions were, quote, unfounded in every respect, unquote. The fact is that I was very clear back in 2008 and subsequently that the whole campaign of untruth, distortions and character assassination by the GSLP and their friendly media outlets was designed as a political instrument to tarnish and smear the reputation of the staff of the Dr. Giraldi home in the hope this would serve them well at the 2011 general elections. It was a means towards an end, without any consideration for the staff and the reputation of the many hard-working employees. I clearly remember members of staff telling me as minister that as a result of the incessant imputations by the GSLP-friendly media outlets, they felt that they were being personally identified in their private time outside their homes. They felt badly let down by the comments of the members of this House in the TV program of Espejo Público, which led to the producer to describe the Dr. Giraldi home as, quote, the House of Horrors. This was a shameful and disgraceful episode by members opposite for which they have never apologized, despite the harm done to these employees, the residents of the home or their families. Well, today the Chief Minister is given the opportunity to apologize for the participation of his party in that program. If he does not want to write to the producers of the program, as the motion suggests, the least he could do is to apologize. In relation to Mrs. Hernandez, I will repeat what I have said on a number of occasions, and that is that I feel sorry for this lady. Any objective analysis of the inquiry report will demonstrate that this lady was not fit to be the manager of the home, and I will not go any further than that. I will say, nevertheless, that those who did advise her from the GSLP Liberal Party did not have her best interests at heart. Instead of providing the best possible counselling, she was used as a political pawn for partisan interests. Mr. Speaker, given the outcome of the inquiry, which is a complete political fiasco for the GSLP Liberal Party, some kind of pseudo-defence will need to be invented in order to justify the unjustifiable. And in fact, the leader of the House was just seen trying to rewrite the inquiry itself. But in reference to the statement made by the Father of the House, what he has omitted to say, what the Honourable Judge did say in Volume 4, page 668, which says, quote, however, the home has gradually improved during the period under review, that is between the year 2000 and 2005, and especially after 2005 and 6, in terms of staffing, procedures, working practices, and impact of care, unquote. One valid comment that can be said about social services in general is that while increasing its budget well over the rate of inflation in real terms is important, something that is the track record of the GSD government, there is always room for improvement. I always accepted that as Minister with responsibility for social services, but the fact remains that we invested heavily in this area. As far as expenditure is concerned for social services, the GSLP government inherited a budget from the ACR government in 1988 of £412,000, and by the time they left office in 1996, the budget for social services stood at £1 million. This represents an increase in real terms after adjusting for inflation of 71.6%. As far as the GSD government track record shows, we inherited a budget of £1 million in 1996, and by the time we left office in 2011 it stood at £5,814,309. This represents an increase in real terms after adjusting for inflation of 321%. One of the ironies for me about the criticism by the Father of the House in our handling of social services was his own track record. After construction of the Dr. Giraldi home under the auspices of the then GSLP government, the building remained closed for 2 years because, in the words of the then Chief Minister, quote, the government could not afford to employ professionals, unquote, and is enhanced. After 2 years in which the home was closed to vulnerable service user, it was then decided to open the home, run by a Catholic charity on a shoestring budget. That only happened after much pressure from the families of the potential service users and their association. In other words, under GSLP government, run by the man who orchestrated the Dr. Giraldi Home campaign, when we were in government, the Dr. Giraldi Home was not even run by social services directly, but rather by a church charity. This contrasts sharply with the decision we took when we were elected in 1996, when we took over responsibility directly for the home and kept it growing in staff and resources throughout the years we were in government. It grew from a handful of staff under the GSLP government to well over 50 by the time we left office. Included were 6 qualified nurses specialized in mental health and learning disabilities, among other areas. I also take note of the comments by Sir Jonathan in relation to the secondment of Mr. Carlos Bandera under my term of office, in which he is credited with further advancing the home policies and procedures and improving further the relationship between service users and staff and their families. Mr. Speaker, using people as a means towards an end, regardless of the harm done to people, is not new. It has, unfortunately, a very long history in the annals of political life and history. Perhaps the first person to describe its usage in political philosophy was Niccolo Machiavelli in his famous book, The Prince, written in the 16th century. Ever since then, we have come to apply the term, quote, dirty hand, to describe the use of campaigns designed to denigrate, mislead, distort, manipulate, torment, and to generally formulate smear campaigns on political opponents. With the passage of time, history will tell us that the Dr. Giraldi Home inquiry and the years of underhand tactics used by the then GSLP Liberal opposition was indeed part of the dirty hand orchestrated campaign to undermine the GSD government, even if it had the effect of tarnishing the morale and the staff of the Dr. Giraldi Home and causing untold cruelty to the staff in their professional and private lives. This type of politics, which uses people as a means towards an end, in general is wrong. But in a small community as Gibraltar, it is even worse, as the effects are more pernicious given our size and the fact that there is no hiding place for anyone. We cannot have a situation in which a political party devises a strategy to get into government by using vulnerable people, by denigrating workers in the institutions that are employed to serve, and not have regard of the misery and anguish done to such staff, service users and their families. As a community, we need to move away from having another repetition of using workers for party political ends, as we saw with the political industrial unrest artificially provoked by the GSP party in the then Caverna shipyard, placing hundreds of workers in the unemployment list in order to create financial problems to the GSD government. Whilst I don't expect that the party in government today, which is the party that caused so much damage to the morale of workers of the Dr. Giraldi Home, the resident and the family, to apologize for their actions when in opposition, I do believe that the motion in front of us does provide an opportunity to undo some of the damage done. We should all vote in favour and raise the standard of political behaviour for the future. Thanks, Mr. Speaker.
The Honourable Chief Minister.
Mr. Speaker, can I start, first of all, by congratulating the Honourable Father of the House for what has been, in my view, one of the most passionate and masterful interventions I've seen him make since I was elected alongside him in 2003. I have told him, although he does not take it as a compliment for reasons I find a difficulty in fathoming, that his forensic analysis is worthy of one of the best lawyers at the bar. But he doesn't quite like those analogies. I am not the only one who makes such an analogy, as we will see in a few moments, Mr. Speaker. And all of us who make it mean it in the positive. In fact, Mr. Speaker, those who have seen me give an interview in relation to this matter of the Dr. Giraldi home will have seen that the government was in fact ready to let matters lie and move on, Mr. Speaker. But in fact, honourable members, it appears, want to simply use this matter to continue to stir and actually do exactly what Mr. Neto has said should not be done. In other words, use the allegations that have been made against vulnerable people in a way that is designed simply to gain them some political advantage. So, Mr. Speaker, it may be that there is a lot more to be said about the allegations that were made not by Joana Hernandez or by Joe Bossano, but by the relatives and indeed on one occasion one of the alleged victims themselves of what might have been happening at the Dr. Giraldi home. Mr. Speaker, the Leader of the Opposition started the afternoon by talking about the government wanting to bury a debate on the motion because we are having the sitting late in the month and because it may be late in the afternoon. Well, Mr. Speaker, in fact, what happens is that the government has a very busy agenda. The government has an extraordinarily ambitious manifesto, one that we are fulfilling. But of course, civil servants are available until 3:30, and we need to be in the office working with those civil servants on matters which really advance our economy and the needs of our community. And coming here to debate motions, even our own, is not something that should take priority over the delivery of the manifesto that's in the interest of our community. So we come here, Mr. Speaker, once the civil servants whom we work during the day are finished for the day, and we can continue because we want to, in this Parliament, to deal with these issues. But, Mr. Speaker, when he talks about, because we're coming late, wanting to bury the motion, he needs to be reminded, Mr. Speaker, that this is the latest the Parliament has ever sat whilst I have been Leader of the House. But it frequently sat until this time and later, when the Honourable, the now backbencher, used to be Leader of the House. It only used to meet twice a year or twice when there was an election, 3 when there wasn't, and it frequently sat very late indeed. I often hear honourable members who have been here longer than most remind me of the fact that Parliament used to sit so late. So either sitting late is just an incidental matter which relates to the important timetable of ministers, or it's an attempt to bury debate, in which case he is now the leader of a party that has form on this matter, having sat later more often than any other previous government. So it may be, Mr. Speaker, that what he's doing in now decrying that is simply once again demonstrating his duplicity and duality politically by saying one thing, although he's leading the party that did the other. Typical, Mr. Speaker. Or he's just repositioning his party. In other words, converting the GSD into the GSLP, as he appears to be trying to do in so many other areas. The fact is, Mr. Speaker, we have no desire to bury this motion. We want everyone to hear what we have to say in respect of it. I want everyone to know what the Honourable, the Father of the House, has said. His forensic analysis has been absolutely superb. It has set out all of the reasons why there should be serious concern in this community about what happened at Giraldi. Mr. Speaker, in particular, I would like the community to know about the copy-paste job that was done on the business plan, and which he has demonstrated to us today was in fact therefore not a document worthy of being praised by anyone, unless of course you are of the school of those who copy the prefaces to manifestos word for word and simply change the name at the bottom. I can't imagine who in the recesses of my memory I might recollect ever did that. Ah, yes, the now backbencher who did it at the time with a Liberal manifesto issued by Mr. Paddy Ashdown in the campaign in the 80s, which became, I think, his forward in the early 90s. Copy-paste job it was, Mr. Speaker. So I want to thank the honourable gentleman for reminding us of that and giving us an opportunity to reflect on that. I want to declare, Mr. Speaker, before I get into the meat of what I'm going to say, that I was involved in these matters when I was a lawyer. I was involved in representing Joanna Hernandez on the instructions of Unite the Union. I also represented before then, also in the instructions of Unite the Union, those referred to in paragraph 4E of the executive summary. In part 4, Mr. Speaker, of the report. And I, in fact, was provided with a letter, which honourable members will not have seen because the matter I'm going to come on to never was dealt with, but a letter by Unite confirming that I could deal with the Joanna Hernandez matter, although I had dealt with the matter of the individuals referred to in paragraph 4E because they waived their conflict in this matter, Mr. Speaker. But I was also, Mr. Speaker, the subject of a complaint to the Admissions and Disciplinary Tribunal of the Bar, brought on behalf of Michael Feetham, who I understand is related by blood to the Honourable the Leader of the Opposition, and Unite, represented by Mr. Raphael Ben-Saken, who was shortly with us in the gallery but appears to have left, and erstwhile member or current member of the Executive Committee of Members Opposite, in an attempt, Mr. Speaker, to seek that I should be disbarred, Mr. Speaker. It is important that I make those declarations, Mr. Speaker, because I'm going to come on to matters which relate to that. Mr. Speaker, the fact is that on the 9th of December 2011, people voted for a change of government. And in doing so, those of us who were elected believe that we have an obligation to comply with the commitments that we gave the public in the general election. And those commitments include, and if honourable members read the inside page of our manifesto, not just the things contained in our manifesto, but also the things which were said in press releases during the course of the previous year. And Mr. Speaker, in a press release, and this is just one of them, in a press release dated the 11th of February 2009, the policy of the opposition, the GSLP Liberal opposition as it then was that we reiterated that a full independent inquiry into the allegations should take place. And our manifesto says all our commitments are in this manifesto or in some of the press releases that we have issued. It was therefore included, Mr. Speaker, in the case we had laid before the public in the 4 years leading up to the general election, that there should be an inquiry into the allegations made in respect of the Giraldi home. We urged that they should have done it whilst they were in government, and therefore in convening the inquiry, I was giving effect to the will of the people that had chosen this particular party, that had made those representations during the course of the lifetime of the previous Parliament. And Mr. Speaker, why did we do that? Let me just quickly, in general terms, try and summarize that. These were not the sorts of allegations that honourable members sometimes faces with. Honourable members get up and say, well, I have been stopped in the street by a person who has told me, or we have heard rumours that. If we were basing ourselves on that, honourable members might have an argument for saying you're really blowing this out of all proportion. I mean, people can stop you in the street in Gibraltar, especially if you are politically responsible for something, and tell you just about anything that you would like to hear. Certainly, I have heard things about honourable members opposite that I have said to myself, even in my wildest imagination, of how dreadful members opposite can be to me across the floor of the House. I know that they would never venture not to care about children or etc. Because people just say things. But this is not people just saying things, Mr. Speaker. The situation in which the Honourable the Father of the House found himself was an invidious situation indeed. He found himself in possession not of notes, not of rumours, but of sworn witness statements. Sworn witness statements which made allegations that abuse and misconduct, etc., had taken place. In the United Kingdom now, Mr. Speaker, we are seeing a flurry of activity, convening an inquiry into alleged child abuse based on things that have been said and documents that might have existed. There is going to be an inquiry into whether there was a dossier that alleged that there might have been child abuse by certain individuals in the past. Not that there is a dossier with sworn statements in it that makes the allegations, but that there is a rumor, there is a belief, there are allegations that there were allegations in writing at some stage. the Honourable the Father of the House finds himself actually with sworn statements making these allegations. And in that context, he acts entirely properly in the way that he deals with this. Speaker, the Honourable Gentleman has said that we should apologise, or we should seek to clarify to Espejo Público what has happened and correct the defamation he has said that they did on Gibraltar. Well, Mr. Speaker, we will come to what was said in Espejo Público and what defamations there were or were not. But I'm left, Mr. Speaker, with just one feeling in all of this, and that is that the way that honourable members have phrased everything they have said about the Dr. Giraldi home, they would only consider that the money in the Giraldi inquiry was well spent if there had been explicit findings of massive abuse. Because the findings are not that there was nothing, as we will come to now, although the ones that we've been read by honourable members are very selective. So I'm going to read him some more, Mr. Speaker. But is it only that if the real abuse of the sort that one cannot even imagine or think about was found, then this would have been money well spent, otherwise it's wasted money? Well, let us look in detail at what it is that the inquiry has found, and what it has found did happen. Mr. Speaker, what hasn't yet emerged, and given the speech that we heard from the Honourable the Leader of the Opposition, is that he's not just a mere bystander here. He's not just somebody who comes to this politically after the findings. It's not just that he was Minister for Justice whilst litigation was going on, dare I say it, in the courts for which he was tangentially responsible by his brother. But look, he can find himself in that situation. That's quite normal, and there's nothing wrong with that, as long as he didn't involve himself with it. If he did, then something else would have to be said, and perhaps we will come to that during the course of my intervention. Mr. Speaker, the speech that you have heard from the Leader of the Opposition today, critical as it is of Joanna Hernandez, probably in the most aggressive terms I have heard a person who is not here to defend themselves being spoken of in this House, was uttered by her first lawyer. The person who was first instructed by Joanna Hernandez was not Fabian Picaldo, it was Daniel Feetham, Mr. Speaker. And my instructions at the time were that he was very concerned to hear what had been put to him, was going to take the case as far as it could, as usual with the Honourable Member, Mr. Speaker, the enthusiasm when one first meets him, going to go as far as we can, we'll uncover all of this. But then there was what lawyers call, Mr. Speaker, in Latin, a novus actus intervenens. Something happened between him meeting Joanna Hernandez and being ready to take the case and my becoming involved. Black turned to white, night turned to day. The socialist turned to the Social Democrats, and the Labour Party was swallowed up whole. And the Honourable Member who had come to remove Peter Caruana from the post of Chief Minister of Gibraltar forgot that he had come to bury Peter, not to praise him, and ended up sitting alongside him in the executive of the GSD. And so he said to Joanna Hernandez, I may not be able to continue with this, because these now contain these allegations against the government, and I'm now in the executive committee. Well, Speaker, if he had left it at that, perhaps, but when Joanna Hernandez instructed somebody else, namely me, through Unite, who were prepared to fund him or me during the case, because we were both at, dare we say it, Hassan's, Mr. Speaker, the Honourable Member refused to release the file. For quite a while, he had to be cajoled and even written to release the file, not to another firm, to another lawyer within the same firm. Incredible, Mr. Speaker. Incredible then, but to have heard him speak the words he has spoken today, for Joanna Hernandez's first lawyer and confidant on these matters, to have got up and said the things he has said today, demonstrates once again the duplicity and the duality of the honourable gentleman opposite. Mr. Speaker, her knight in shining armour, as he then was, turned to rust. Her white knight turned to darkness, as we all know, and her faith in him, like the faith that so many others might have had in him, entirely dissipated. He started, Mr. Speaker, by saying that members of staff at Dr. Giraldi have stood steadfast over the years whilst the GSLP did this and that and all the rest of it. And he wanted to congratulate them all for having stood so steadfast. Does he know, Mr. Speaker, that there are only 5 members of the Dr. Giraldi home employed today who were employed at the time of the allegations? So I don't know who it is that, as a cadre of staff, all stood steadfast. But I suppose when he then says, how can we accuse them, from the government to the opposition, of doing Gibraltar down when they say the things that they do? That we should look at what we did in the Espejo Público, we should judge him by the same standard. You know, I want to congratulate all the staff, you know, probably 30, 40, 50 of them, now just 5, all the staff that stood so steadfast. Mr. Speaker, he calls Joan Hernandez our political activist. Well, he talks about my having represented Joan Hernandez at the directions hearing. Yes, for all the reasons that I told him. But listen to this. He calls her our political activist. He was his client, she was his client before she was my client, or saw Joe Bossano looking after her. He had the chance of having dealt with this matter. He says that I represented Joan Hernandez at the directions hearing, but he didn't bother to say to you, because I'd been her lawyer first, I'd given up the case, and they had to prise the file from my fingers. And he says that our accusations were vile. But he doesn't say that the accusations were all of them related to him, and he was ready to take the case, except that he made a political pirouette of the sort that Gibraltar does not often see, and it was only that determined that he would not. So much for things being vile. But maybe, Mr. Speaker, it's because he forgot. And, you know, last time when we were having a debate which led to the motions, I invited him to say that he simply forgot. This time he, I don't think, will want to accept that he forgot that he had represented Joan Hernandez and he was her first lawyer. But he says so many things, Mr. Speaker, that he is capable of forgetting a lot of what he says, because he just says a lot. Because, of course, he says a lot, but it doesn't mean anything, Mr. Speaker. And in fact, one of the things that we're going to come to, especially when we look at what was said in Spain and what he'd like to think was said in Spain, is that he's obviously forgetting things. This is about his selective amnesia. In fact, Mr. Speaker, they don't like it when we remind them of the enchufes, of the £8 million that they buried in the hole that was the Theatre Royal, the £90 million airport, the Roja tanks, the defective works at Cumberland. They don't like to be reminded of that, but they like to remind us about the Dr. Giraldi home inquiry. Well, we're delighted to be reminded about it, Mr. Speaker. But maybe he's just suffering again from the same amnesia that made him forget that he was the lawyer for the Sunborn, the same amnesia that made him forget why he'd originally come to Gibraltar, or the same amnesia that led him to say that the man that he'd come to remove was actually the greatest Gibraltarian of all time. Mr. Speaker, there's so much amnesia in the gentleman opposite that I sometimes think that I should serenade him with a verse of that great song from Andrew Lloyd Webber, Memory. But the more that he goes on, Mr. Speaker, and the more that he says, I actually think I should go on to another song in that musical, which is Bring in the Clowns. Because what he's done today is not deal with the Giraldi home inquiry and its findings. He has wanted to read an indictment of the Vox newspaper. He has wanted to talk about how the Vox newspaper said this or said that. Well, look, Mr. Speaker, the Vox newspaper is no longer printed. They managed to do that, Mr. Speaker, by a combination of aggressive litigation in which his brothers and he was involved, and by withdrawing advertising. They brought the title which had been, until then, the longest surviving title in Gibraltar's media history, to its knees, destroyed it, and now it is only a web publication. They say that we spread unfounded allegations in Spain in Espejo Público, that Gibraltarian politicians, namely the father of the house, became participants in Spain on TV programs denigrating our institutions. I can't actually think that the honourable gentleman has bothered to do his homework if he said that. He can't have bothered to watch the YouTube video of Espejo Público. You can't ever accuse us of doing Gibraltar down, given what you did on Espejo Público. We haven't even had an apology for your shameful intervention. Mr. Speaker, the Honourable Father of the House took him to it. I'm going to take him to a different part, which includes the part that the Honourable the Father of the House read. He either, Mr. Speaker, has not done his homework, or he realized after he put the motion that he just remembered there was a program called Espejo Público, but hadn't checked what had been said on it before putting pen to paper. Maybe that's a case of pen engaging before brain. Mr. Speaker, the interviewer from Espejo Público says something in the clip, which the Honourable the Father of the House is going to be very angry at indeed, Mr. Speaker. Because he starts, and I'm going to have to read in Spanish, Mr. Speaker, but I will do a little bit of translating. He starts by saying this: El abogado Joe Bosano. Spanish TV programs never do their research on Gibraltar. Ex-presidente de Gibraltar. Don't they realize he is just president for life of the youth section of the GSLP? Ha tardado 3 años en demostrar que Joana Hernández fue despedida procedentemente. No fue despedida procedentemente. Como líder del Partido Laborista también ha intentado que se aclare lo que ocurre en este centro. So they're talking about Dr. Giraldi. They say it's taken him 3 years to demonstrate that she has been unfairly dismissed, and that as leader of the Socialist Party, he's trying to show what happened in this place, the Dr. Giraldi home. And then Joe Bosano says, Mr. Speaker, these dreadful words, which are the most disgraceful and vile defamation of an institution in Gibraltar that I have ever read, if I were to believe the honourable gentleman's description of them. And this, Mr. Speaker, is what this House is being asked to resolve, to right and correct as a result of this disgraceful man's disgraceful statements. Yo le pregunto en el Parlamento, bueno, si todo esto es un montaje y todo es mentira, entonces ¿por qué no se permitió que se escuchara el caso el primer día, en el 2006? No lo ha hecho, no lo aclaran. Mr. Speaker, what Joe Bosano said is this. I ask in the Parliament, well, if this is all a stitch-up, a set-up, and everything is a lie, then why didn't you just allow the case to be heard on the first day in 2006? You haven't done so. They haven't done so. They don't clear it up. That is the sum total of the vile and disgraceful defamation of a Gibraltar institution uttered by Joe Bosano, which the honourable member has said we must now write to Espejo Público to correct.
In my office.
And not in Spain, Mr. Speaker, by the way, but in his office. He then goes on, Mr. Speaker, because the clip goes on. El resto de la oposición, el Partido Progresista Demócrata y los liberales también demandan esta investigación. The rest of the opposition, the PDP and the Liberals, also demand such an investigation. Nadie se atreve a asegurar en Gibraltar que las acusaciones sean ciertas, pero mientras no se aclaren los hechos, siempre quedará la sombra de la duda. Nobody in Gibraltar dares say that the allegations are true. Neither was Joe Bosano saying that they were true, incidentally. That the accusations, but until the accusations are clarified, the facts are clarified, there will always be a shadow of a doubt. Well, Mr. Speaker, that was the policy of the GSLP in Gibraltar, that there should be an investigation. and that until there was an investigation, the allegations were being made, and they could not simply be discarded. Mr. Speaker, there's an incredibly instructive set of paragraphs or exchanges where honourable members might like to know that the interviewer is saying that actually we've had great difficulty getting people to speak on camera, because although they tell us on camera that these things might be happening and they have to be investigated, they won't come on camera because there is great fear. Fear of what? Says the lady in Madrid to the guy in Gibraltar. Fear of the administration and taking on the administration. Well, Mr. Speaker, if there's one thing that people have been cured of on the 9th of December 2011, it is having fear of the administration, because people now talk freely. But the Espejo Público report went on, and it dealt with this issue. Pero es tan grave el asunto, es decir, que hay tanto miedo y tanto temor en Gibraltar, que en principio hay que denunciar que un niño de 10 años que entra allí por motivos emocionales le metan directamente en un centro psiquiátrico con 10 años y que no lo separen a los niños de los adultos ahí. Mr. Speaker, essentially these people are saying it's a very grave matter. To such an extent, there's great fear in Gibraltar. People don't want to talk, but we have to say that one of the issues to look at is that a 10-year-old boy has been put in a mental home with older people. Another defamation, apparently, Mr. Speaker, but not one uttered by Joe Bossano. As it turns out, Mr. Speaker, entirely true. Now, the honourable gentleman and I do not rate each other as lawyers. That's fine. It's up to other people to rate us as lawyers. But he should know, Mr. Speaker, that a defamation is something which is uttered which is untrue, not something which is uttered and then found to be true. And so, what we shouldn't do, Mr. Speaker, is fall into the trap of putting pen to paper as quickly as the honourable gentleman did in drafting the motion, to write to Espejo Público, because we might find ourselves writing a letter that says, your report was true in respect of the 10-year-old boy. Your report was true in respect of the 10-year-old boy. And if I were writing the letter, Mr. Speaker, I would also say your report was true about the fear that people felt in speaking out against the government at the time. So the honourable gentleman has to be a bit more careful with what he wishes for. Otherwise, he might just get that letter. Mr. Speaker, nobody went on Spanish TV, therefore. Spanish TV came to us, and what was said by the Honourable, the Father of the House, is actually entirely defensible in the sense that it made no allegations against anybody other than to ask why things were not being investigated. But he says, you are now suing Avese, which we support. If you're suing Avese to put the record right, why don't you get this letter out to Espejo Público? Well, Mr. Speaker, what we have done is exactly what we promised to do, and exactly what Joe Bossano was talking about in Espejo Público, which is to say that the allegations should be investigated. And being elected, we gave the opportunity to those making the allegations in the setting up of the inquiry to come forward and say what they had to say. We never said that the allegations were true. We never said that these were our allegations. In fact, all we said is the allegations are made and they must be properly and entirely investigated. And having done so, Mr. Speaker, we can happily say that the silence has been broken and the inquiry has been held. Now, Mr. Speaker, the allegations have been, which were made, the Honourable Gentleman said, were found to be totally unfounded. Well, Mr. Speaker, they were only investigated as a result of the inquiry being called. So I assume if his case is that the allegations were unfounded, if that is what he's trying to persuade public opinion of, then he should be grateful for the inquiry, because it is the only place in which the allegations have been properly ventilated. And what he says was his theory all along proved right according to his reading of the inquiry findings. But, Mr. Speaker, let us look at the findings, because the Honourable Gentleman has offended against the rule there would be if this were a tribunal of only reading selectively the bits that he thinks are convenient to his case. But what about all the other bits, Mr. Speaker, that Chairman Parker determined in his conclusions? Let me read you from page 636. The shortage of staff was serious and chronic problems which added to the pressure on management and staff, including support workers, is his first finding. Second finding, greater training of staff would have been beneficial. During this period, no care plans in the sense of formal and comprehensive care plans which included input from social workers were in place for service users. Record keeping and control of paperwork was not as efficiently carried out as it should have been. Missing paperwork was a real and continuing problem. This is not, Mr. Speaker, in an office. This is in a place where children are in care, where adults are in care alongside some children. The frequent changes in management personnel contributed to this problem, not only because such changes involved a degree of disruption to the smooth running of the home, but also because handovers between one manager and the next were carried out in relatively perfunctory manner, to the extent they were carried out at all. What if one of your relatives were being looked out after with this system in place? There were also continuing problems throughout this period in relation to the management of petty cash. One of the allegations relates to petty cash. Lack of control of medication was also a continuing problem during this period. Not in one's home, Mr. Speaker, but in a home run by the government. Lack of control of medication. On one occasion, a resident was given a repeat dose by a carer coming on shift who did not know and had not checked whether the dose had already been given. And these people are in the care of the government, Mr. Speaker. On other occasions, a resident was either under or over-medicated. These incidents demonstrate that procedures in relation to control of medication during this period could and should have been improved. Some of the allegations related exactly to that. The physical facilities at Bishop Healy, which was used by the home as a temporary measure following flooding at the premises at Smith Doreen Avenue, were inadequate. Didn't hear him read those findings, Mr. Speaker. Joanna Hernandez's efforts in this respect were supported by Sean Matto. Mr. Speaker, they're talking there about the shortage of staff issue. In a contemporary report in which he described the effects of the shortage of staff under them, the great investors, as Mr. Neto described them, as at best unfair and at worst abusive. With greater numbers of staff, a higher standard of care could have been provided. Shortage of staff also resulted in members of staff becoming seriously overstretched. Throughout this period, there were continuing problems in relation to the control of medication and in relation to lack of security. I accept Joanna Hernandez's evidence that she attempted to improve the physical activities at the home and that she introduced a number of improvements to the running of the home, including arranging for regular group meetings with relatives of service users. Her first lawyer didn't refer you to that, Mr. Speaker. Let him leave it to me, and I will. On one occasion, says the report, another resident was locked in his room in the dark. That was inexcusable conduct by the carer responsible, but the evidence is that such conduct was stopped. But it happened, and that is what the allegations related to, Mr. Speaker. I didn't hear Joanna Hernandez's first lawyer read you that bit. Or this bit, Mr. Speaker. In her evidence to the inquiry, Simi Herbert alleged that members of staff used to speak disrespectfully to residents. I do not doubt that that may have happened on occasion, and clearly it should not have happened. All of the allegations, in fact, are slowly being made out. It's just a question of degree. And a lengthy section here, which is important, Mr. Speaker, because it goes to the crux of what happened. Chris Wilson's evidence in relation to the availability of Isabella Tosso was singularly unhelpful. He wholly failed to give that matter the importance it deserved or to treat it with an appropriate degree of urgency. And this relates to the Industrial Tribunal, Mr. Speaker. The fact that he made no effort himself to discover how to contact Isabella Tosso beyond making inquiries of some of his colleagues demonstrated a quite remarkable degree of passivity on his part. Marie Gomez told the inquiry that she had not seen or heard of Ms. Tosso since 2007. That is inconsistent with the fact that the latest in the series of emails referred to earlier was an email from Isabella Tosso to her dated the 12th of August 2008. in which Isabella Tosso described her as my friend and signed off with kisses. The curse of modern email, Mr. Speaker. Asked whether she was aware at the time of the substantive hearing that the fact that Isabella Tosso would not be available to give evidence meant the SSA would not be in a position to defend Joanna Hernandez's claim, Marie Gomez said in effect that she was too busy with her work to think about anything else. I do not believe that answer. That's what the report says. In the course of their email correspondence, Isabella Tosso gave Marie Gomez her office telephone number in the UK. Asked why she had not tried to contact Isabella Tosso on that number, Marie Gomez replied, "To tell you the truth, I did not even realize I had the office number. I probably scanned the email and just, went on working. I was too busy." I do not believe that answer, says Chairman Parker, and goes on. Marie Gomez went on to give a number of equally evasive answers to questions from counsel. They demonstrate, beyond any doubt, that during the period leading up to the substantive hearing on the 9th of April 2008, Marie Gomez not only knew how to contact Isabella Tosso, but was in regular contact with her, and that they remained in contact thereafter. Her repeated attempts to disguise this obvious fact in her oral evidence cannot be attributed to a faulty recollection. Her evidence on this aspect represented, for whatever reason, a deliberate attempt to mislead the inquiry. Joanna Hernandez's first lawyer didn't think he should read you that, Mr. Speaker. He was only interested in laying into her, not reflecting what the reality of the inquiry report sets out. And it goes on. As to the unavailability of Isabella Tosso, there is no evidence that Chris Wilson's passive attitude in relation to her unavailability represented a deliberate attempt on his part to prevent or delay discovery of her whereabouts, but I am satisfied that it was a simple case of slackness and inefficiency on his part. The human resources manager of the place where we're putting some of us are putting our relatives to be looked after. And Mr. Speaker, slightly better things. Overall, the evidence presented to the inquiry paints a healthy picture of the current state of affairs of the home. According to the evidence of Gina Gianello, the perennial problem of staff shortages continued during that period when the Honourable Great Investor, Mr. Neto, was at the Social Services Agency, investing more money than anybody had ever invested. However, the problem has been addressed to the point where it is no longer so pressing, not under him. In consequence, the standard of care which the staff are able to offer service users is higher. And finally, Mr. Speaker, in Chairman Parker's general conclusions, I don't know, Mr. Speaker, why the Honourable Gentleman didn't read you the first one. There were some instances of mismanagement, misconduct, and malpractice, including abuse at the home, but they were infrequent and at the lower end of the scale or seriousness. But he says there were some instances of mismanagement, misconduct, and malpractice, including abuse. Can somebody explain to me, if I was a relative of one of the people who was subject to mismanagement, subject to misconduct, subject to malpractice, or indeed subject to abuse, how anybody is going to persuade me that something is at the top or bottom of a scale of seriousness when I have entrusted one of my relatives to the care of the administration? The second conclusion, many of the allegations in the witness statement filed on behalf of Joanna Hernandez in the Industrial Tribunal in 2006 were untrue, grossly exaggerated, or unsubstantiated by credible evidence. Well, that sounds a bit negative of Ms. Hernandez, doesn't it? I think the Honourable Gentleman did read that one. Her first lawyer did read that conclusion. But read this forensically, Mr. Speaker. Many of the allegations in the witness statement. Any lawyer who reads that realizes it doesn't say all. It doesn't say all, Mr. Speaker. Mr. Speaker, the third conclusion is, in relation to that, as follows. To the extent that such allegations were established on evidence, the incidents in question were largely historic and infrequent. In other words, Joanna Hernandez's witness statement contains truths which are proved, but they happened some time ago and it didn't happen too often. Well, Mr. Speaker, if it was one of my relatives, I don't care if he's been abused once or twice, 10 years ago or 20 years ago, he has been abused, and I wouldn't want to watch any of my relatives abused when he's in the care of the administration. But let's end on a positive note, Mr. Speaker. And Sir Jonathan Parker says this. On a positive note, however, I can report that the home is now in much better order and is better run than it has been at any time during the period which the inquiry has had to investigate. Well, Mr. Speaker, so much for there being nothing in the findings that supports the decision that we should have carried out this inquiry, or that we were wrong once we were in opposition to be pursuing it. Because, frankly, Mr. Speaker, I think for all of the relatives of the people who made allegations, there is a lot in there to feel uneasy about. In other words, there is a lot in there which they were found to have rightly raised issues about. But the honourable gentleman, in his hyperbole, went on and said, in no Western democracy could somebody get away with having said the things the father of the House said and still be a minister. Well, Mr. Speaker, in fact, the honourable gentleman was speaking on the basis of having sworn witness statements in his hand. He was acting entirely properly. But I have heard before in this House this business of in no Western democracy. As Hansel will show, it was said once before, in a budget, I forget the exact year, but I think it was after 2007, when the honourable gentleman, the now backbencher, in other words, the one who is now out of government, said to the honourable the Father of the House, in any other Western democracy, anybody who'd lost 4 elections in a row would have to resign and leave the Parliament. Mr. Speaker, they used to call Bill Clinton the comeback kid. He's got nothing on the honourable the Father of the House. And Western democracy should take lessons from the way that Joe Bossano discharges his obligations to the people that he serves, namely the people of Gibraltar, whether as a minister or as a member of opposition, pursuing doggedly many of the things which the chairman of the inquiry has actually found he was right to pursue. Aided and abetted by members opposite, said the honourable gentleman, trying to convert his diatribe into an indictment, because the language of aiding and abetting is the language of the criminal law used in indictments. Well, aided and abetted, Mr. Speaker, well, supported by his party, who adopted as a policy position that we should pursue this inquiry. But does he include Unite, that for a period were actually involved in funding Joanna Hernandez's case? Does he include himself, her first lawyer, or only those of us who remain, not have been in the past, those of us who remain members of the GSLP Liberal coalition, to be tarnished as aiding and abetting when we are in fact doing is supporting and ensuring that the light of day shone on those serious allegations, many of which have been found to be true. Mr. Speaker, he, I think, gave a backhanded compliment to the GSLP political machinery, as he called it, talking about the intensity with which we pursue things, and went on to say that as fathers of children, we should not have wanted to be associated with the way that the GSLP pursued this matter, never mind the fact that the inquiry, which he quotes, actually finds that we were right about many of the things that we were pursuing, certainly that they should be investigated. But, Mr. Speaker, let us look at the opposite of what he said. And the honourable gentleman doesn't do logic very well. That's why he sometimes does things that which are, when they are exposed to logic, can be demonstrated not to be exactly, I think, what he might have wanted to say. As father of children, we should not have allowed this to happen. Well, actually, Mr. Speaker, as father of children, what all of us should want always done is that if there is the slightest shred of credible evidence, in particular, sworn witness statements, not one but many, we should all want them investigated quickly. We should not prevent investigations from being carried out. As fathers of children, we should ensure that nobody again has to go through the political persecution that Joanna Hernandez has had to go through to have her allegations, or rather, the allegations made by others in support of her in the Industrial Tribunal, properly investigated. As fathers of children, we are receiving an example in the way that in another Western democracy in the United Kingdom, rumors of potential child abuse are being dealt with, let alone witness statements that dealt with child abuse. But, Mr. Speaker, did it all end there, or was there much more to this? Was there an attempt not to have this case heard? despite the witness statements? Was there an attempt to, at the last minute, say that the case was collapsing because Isabella Tosso couldn't come when that might not have been the reality? Was there, in fact, Mr. Speaker, actually much more going on here? Well, Mr. Speaker, this didn't just affect Joan Hernandez. The Vox is no longer published today, as I told members before. The Vox was the subject of a libel action by members of the Honourable Member's family. I believe he was involved in that despite being Minister for Justice. Mr. Speaker, I was the subject of a complaint to the Industrial Tribunal by members of the Honourable Member's family. And I'll tell him, Mr. Speaker, because he likes to use the hyperbole. Shameful and disgraceful. I've told him before, Mr. Speaker, what was shameful and disgraceful is not that somebody asks him when he's talking about something that involves Hassan's to simply declare his interest. What is shameful and disgraceful, and what is pressure, is to try and have somebody not declare an interest, but disbarred. To try and snooker them politically, to somehow try and avoid them becoming a political challenger, to somehow in that way make your way up the greasy pole that the honourable gentleman makes politics in Gibraltar. To almost think of it as snakes and ladders and try and push your opponent over a precipice, Mr. Speaker, which is exactly what the honourable gentleman was doing when he was behind the attempt to have me disbarred in that way. And all of that, Mr. Speaker, I might even forgive. I'll certainly not forget, but I might even forgive. But what I will never forgive, and I will not tire of reminding him of, is that that complaint was not just a matter being dealt with, but it was a matter which they insisted should go to a case management hearing the day after my father died. Knowing that my father had died, having been asked for an adjournment, they insisted, with all of the venom with which they pursued Joanna Hernandez and me and Vox, that I should be there, listening to the total poppycock that was coming out of their lawyer's mouth, namely Mr. Rafael Ben-Sakeng, now a member of their executive, then receiving approximately £250,000 a year for the work for which he had been paid £60,000 a year as a civil servant, instead of being with my family and my mother on such an important day. For that, Mr. Speaker, I will never forgive them, Mr. Speaker. That is disgraceful and that is shameful. And in Spanish, in the espejo público language, se le debía de caer la cara de vergüenza, pero no la tiene, Mr. Speaker. But, Mr. Speaker, let us look at what it is that we can conclude from what has been said today. What we conclude from what has been said today is that we should have actually, together as a parliament, convened an inquiry when the allegations first came to light, which was what the opposition was asking that we should do in the questions put at the time and the debates that we had at the time. We should have allowed the Industrial Tribunal to go ahead and, not wanting to do that, or as an alternative, convened an inquiry. That is exactly what we did when we were elected. Mr. Speaker, we did not pick this battle, but we would never turn our backs on people who are making serious allegations of the sort that we were confronted with in sworn witness statements. So, Mr. Speaker, there were no defamations to speak of. I've demonstrated to him that in the Espejo Público documentary, the words actually reflect some of the things that did happen, or simply what was happening, namely that we were not getting answers. There is no apology to be made. Certainly not in the terms that the Honourable Gentleman has suggested. But an apology should be made, Mr. Speaker. And he's right to suggest it, and I'm going to make it. I apologise on behalf of Her Majesty's Government of Gibraltar and on behalf of the people of Gibraltar to all of the people who had the guts to make statements, in witness statements, sworn witness statements, making allegations which have subsequently been found to be true by the inquiry, that those matters were not dealt with more expeditiously at the time, although we were not in administration. And given, Mr. Speaker, that the Honourable Gentleman's motion suggests a different sort of apology and suggests that there has been a defamation which has not happened, I am going to move an amendment to the motion. But before so doing, I'm just going to tell the House, Mr. Speaker, that frankly, I don't think anything Mr. Neto said merits a reply or is worthy of a response, because his philosophy has failed him today again, as it always does. Mr. Speaker, although I am not required to give notice in writing of an amendment to a motion, I am going to do so because it is lengthy, and ask the Honourable Clerk whether he wishes to distribute it to honourable members opposite or to yourself. Mr. Speaker, I move that the motion be amended as follows.
I envisage that I will be making a point of order in relation to the amendment, because what the Honourable the Chief Minister is going to do with this motion, what he did with the last one, I have gone back to Erskine May, and it's not allowable in the rules, because in fact he does have to give notice, and I'm just foreshadowing that I may be making this particular point once I read his amendments, which he says are lengthy.
Mr. Speaker, the practice of this House continuously has been, and therefore that overrides Erskine May, that any individual can make an amendment to the motion, or can move an amendment to the motion, and that they do so not even having to do it in writing. And I am doing it in writing today, Mr. Speaker, and my amendment is as follows: to delete every word after the words "this House" and add the following text, as has been the case on numerous occasions, in particular under the former leader of the GSD and myself, Mr. Speaker, and under the Father of the House.
And refer the House to Erskine May, because I had anticipated that this is a point. Well, Mr. Speaker, I am making a point of order. I can make it after he reads it.
Let him
or
read
before,
it, and let me look at the rules of the House in the meantime. The rules of this House. Part 6, motions, right? And I tell the Honourable, the Leader of the Opposition, why I'm doing this. And I think that there are people here who have been members of this House for many years, the longest being Mr. Bossano and myself, and next, Sir Peter Caruana. And on many occasions, I want to check the rules, but on many occasions, a member who has made a speech on a motion has stood up and at the end of his contribution, given notice of his intention to amend the motion, and the amendment has been circulated and considered. And that has happened since I've been Speaker. It has happened during one debate since I've been Speaker, and there was no problem.
So, in fact, it has happened since the Parliament was the Parliament. And Mr. Speaker, what the Honourable Gentleman has to remember is that Erskine May is there to give us guidance where our standing orders do not otherwise provide. And Standing Order 20 says the following, Mr. Speaker, explicitly. Motions
will you allow me to read it?
Motions not requiring notice.
Allow me to read it. The motions which don't require notice are motions. Amendments thereto. I think honourable members should look at Rule 21. Subparagraph 3. Any amendment to the motion which a member wishes to propose in accordance with the provisions of Standing Orders 23 and 24 may be moved at any time after the question upon the motion has been proposed by the Speaker and before it has been put by the Speaker at the conclusion of the debate. That, I am sure, 21(3) is the rule by which the proceedings of this House have been conducted, certainly since 1972, by various speakers on numerous occasions when there have been not just amendments, but amendments to amendments to amendments. And as I say, I've been a member here 20 years, Mr. Bossano has been longer, Mr. Caruana has been here since 1991. This is maybe at a certain time when it wasn't that common, or it was less usual to have debates of the natures that we have had today, you know, maybe that almost fell into desuetude. But I have no doubt in my mind that it is perfectly proper for a member speaking on a motion at the end, at any time during his intervention, certainly before he sits down, to give notice of the motion and having circulated, and then that motion is to be debated. And insofar as Erskine May is concerned, Erskine May does not constitute the House of the Gibraltar Parliament. Erskine May is the Bible of parliamentary procedure by which parliaments that base themselves on the Westminster pattern guide themselves by. Now, having said that, I will allow the Leader of the Opposition to say whatever he wants to.
Well, Mr. Speaker, thank you very much. I mean, normally one hears the submission or the views of those making the point of order before making a decision on the point, Mr. Speaker. Although, Mr. Speaker, appears...
Decision, I am giving you guidance. I mean, I don't have to... The Honourable, the Leader of the Opposition, by objecting to the amendment moved by the Chief, whether it was possible, I understood perfectly well what he was getting at. And as I say, because the practice and the rules are clear, I think I have given guidance. Now, notwithstanding that, I mean, if he wishes to challenge or if he disagrees with what I'm saying, I will allow him to do so by all means.
Speaker, yes. Speaker, yes. Mr. Speaker, the difference is between an amendment to a motion, which is perfectly possible without notice. In other words, one amends a motion, but the motion in essence remains substantively the same, and what he is doing, which is effectively substituting my motion for another motion. That is what... No, Mr. Speaker. If what happens here is that there is another motion altogether completely different to the one before the House now, he has to give notice, Mr. Speaker, because what we are dealing with is a completely different motion. That's what we're dealing. If we were dealing with an amendment of one paragraph, well, perhaps it would be different. But, Mr. Speaker, and that is the...
That is not what has happened in this Parliament or in the House of Assembly. And I regard Mr. Bossano as an honourable person, and he will corroborate. I'm sure that it's happened to motions when he was Leader of the Opposition. He brought motions to the House, and either Sir Joshua Hassan or I myself even, or anybody, would delete the whole of the motion from, delete all the words after this House and substitute by the following, without any prior notice being given. That happened during the course of the debate. I know what I'm talking about. I know that I am supported by Hansard over all these years. I have a very, very good memory, and I have lived, in the 20 years that I was a member, I have lived that situation on countless occasions. Now, that's it. Again, I will invite the Honourable Opposition to continue. But honestly,
I'm not going to... It's not my practice.
You are mistaken. Honestly, you are mistaken. Check with your father, who has been a member of this House and has seen that happen. Check with your father. He will tell you that you are... Check with other people. Check with other previous members who were here during the days of House of Assembly, right? And they will tell you. Contemporaries of Mr. Bossano and myself, you can meet them in the street, you can telephone them, and they will tell you. The only pity is that we don't have alive, at the moment, any of the speakers, like Major Robert Pelissa and Alfredo Vasquez, who were involved when that happened. But I tell you, I know what I'm talking about.
Well, Mr. Speaker, during the course of this evening, I've had my two brothers mentioned, my father, and now the Speaker also mentions my father.
Just a moment.
Mr. Speaker,
please.
May I be allowed to continue?
I will allow you. I will allow. Look, I haven't mentioned your father in a derogatory sense. I have mentioned him as someone with whom I shared many meetings here in the House, whom I hold in very high regard, whom I consider an honourable person and a great friend of mine. So I am not saying anything derogatory about him. I think that you are going a little bit too far in misinterpreting what I am saying. We have been here since 5 o'clock. We've had 3 excellent debates. I'm not being patronizing. Until now, until what has happened in the last 10 minutes, I want to commend all honorable members that have taken part in 3 excellent debates with a lot of passion, with a lot of controversy, but nothing unparliamentary has been said. And for that, members should be commended, because it is very easy. No, now we are having more controversy because it is not that I am making a ruling, it is that I am telling you that you have misunderstood the rules of this House and you don't seem to accept it. That is all.
It's not that I don't seem to accept it. I haven't been allowed to get in a word in edgeways, Mr. Speaker. Mr. Speaker,
now as much time as you want.
does Mr. Speaker? Mr. Speaker. No, Mr. Speaker, look. Mr. Speaker, I have looked at the rules. Indeed, I am not going to mention who told me and alerted me to this, but Mr. Speaker would be surprised if he's talking about authoritative people and people who have been speakers, of the person that actually alerted me to this point, Mr. Speaker. So it's not something that I have invented and I have come here off my own back. I have actually been alerted to this particular point by somebody with experience of his job, Mr. Speaker. I went back to Erskine May and I looked at the point, and indeed that is the procedure as I understand it, that if what you're doing is effectively superseding one motion with another, fairness requires that there be notice of the motion. But look, Mr. Speaker, to the extent that Mr. Speaker is not with me, my practice has never been to push, in court or otherwise, to push at closed doors. So what I'm not going to do is push at a door that is clearly closed in my face in terms of this particular point. And I don't want to delay the proceedings anymore. Mr. Speaker thinks that the Honourable the Chief Minister can proceed with the amendment, which is effectively without notice, and doing away with my motion, introducing a completely new motion, at 5 to 12, well, it was 10 minutes ago, 20 to 12 in the evening, without any notice. And that is fair, and that is, well, that's fine, Mr. Speaker. If Mr. Speaker takes that view, I sit down and let him go ahead with the amendment to his motion.
I am not discussing the fairness of the procedure or otherwise. What I am saying is that certainly in all the years that I have been a member, in all the years that I have followed the proceedings of Parliament, when that has happened, and it has happened on numerous occasions, no one has ever stood up in this House and questioned that procedure. No one has stood up and questioned that the Speaker allowed that to happen. Now, the Honourable the Leader of the Opposition says that he has taken advice. Well, look, I don't know who the advice comes from, possibly from a previous Speaker, but I am not going to make a judgment in disagreement of any previous Speaker. I'm not going to do that, because that I think would be wrong. I have the right as Speaker to make rulings, and when rulings are made, they become, that is the valid ruling, even if it were to go against what a previous Speaker may have ruled. That is the position. It happens in all parliaments and it will continue to happen. Look, I don't particularly enjoy being, my personal preference would have been for the debate to be concluded, because if an amendment is made to the motion, anybody else can now speak on the amendment, and we might be here till midday. And as honourable members know, I don't particularly want to be here till midday on the 2nd of April. It's bad enough on April Fool's Day to have to be here till the present time.
Mr. Speaker, perhaps we can get on with it, Mr. Speaker, and allow the Honourable the Chief Minister to go ahead with his amendments. I can only do, Mr. Speaker, and in my career as a lawyer, in 22 years that I've been in practice, I've always pursued an argument and a course of action that I believe to be the correct one. I believe that the correct course of action is not to allow an amendment that effectively substitutes one motion with another. Because the rules on notice, Mr. Speaker, are there precisely to allow for fairness, because what you're doing effectively is giving notice to the other side that you intend to bring a motion. I understand when there is amendment to one paragraph, but substituting one motion with another without notice does not appear to me to be the right course of action. But I accept Mr. Speaker's ruling, and all we want to do now is to get on with the Honourable the Chief Minister's amendment, and then with my reply to both the Father of the House and the Leader of the House.
Let me say for the record that my ruling is based on the practice of previous Speaker of this House of Assembly and of this Parliament. I am not departing from any. It is what I have seen done, and that is what I have guided myself by. In my view, the greatest Speaker that this Parliament had was the Honourable Alfred Vasquez, and during the 18 years that he was Speaker, that must have happened on umpteen occasions.
Mr. Speaker, just speaking on the point of order, it's very clear that Standing Order 20 envisages exactly this sort of thing happening, as every Chief Minister, as every member who has wanted to move substantive amendments which have removed all of the text of a previous motion have done in the past. The Honourable now backbencher has done it, the Honourable the Father of the House has done it. I dare say in your time it was done, as you've confirmed. And the position is very clear. Standing Order 20 says that motions not requiring notice include the motion by way of amendment to another motion being debated in the Parliament. And, Mr. Speaker, the reference further in Clause 21 is of any amendment. So if the rules in the United Kingdom are different, then they are different, Mr. Speaker. And I don't know who to thank for allowing me to get on, because the Honourable Gentleman seems to have forgiven me my life by saying, let us allow the Chief Minister to get on. It seems that he's given up very quickly. He doesn't have the tenacity that he says he has, Mr. Speaker, in my view. But anyway, I thank you, or him, or whoever it is I should, for allowing me to continue with the procedure that has been pursued in this House since the first day it met as a City Council. Mr. Speaker, this is fast becoming from aquí no se cena to aquí se va a desayunar y nos vamos a comer los caracoles if we carry on like this. But the Honourable Gentleman has obviously become, in fact, very, very nervous indeed about the amendment I am about to move, and I can understand that, because he does not like to be treated like everybody else has always been treated. He believes there should be a fetum rule for everything. Well, there isn't, Mr. Speaker, and I therefore move that we should delete every word after the words "this House" and add the following new text. This House welcomes that the government has fulfilled its commitment to review and investigate allegations of abuse at the Dr. Giraldi home. Recalls that the terms of reference of the report established under the Commissions of Inquiry Act by the Chief Minister were as follows. 1. To inquire into A. Allegations of mismanagement, misconduct and malpractice, including abuse at the Dr. Giraldi home, contained in witness statements intended to be relied on by Joanna Hernandez in connection with her claim of unfair dismissal by the Social Services Agency, and B. The conduct of the relevant authorities and agencies in response to or otherwise in relation to such allegations. 2. To inquire into such other matters relating to the Dr. Giraldi home as the chairman of the inquiry shall in his absolute discretion consider appropriate. 3. To find the relevant facts. 4. To report on the above. Notes that the reporters confirmed that there were instances of mismanagement, misconduct and malpractice at the Dr. Giraldi home, although in the judgment of the chairman these were at a lower level. Regrets the failure of the GSD administration to conduct an independent public inquiry into the allegations of deficiencies in the treatment of persons in the Dr. Giraldi home at a time when numerous individuals and organizations in Gibraltar, including the then opposition, were asking for it. Considers that the position of the present government in having proceeded with the inquiry was in the public interest and fully vindicated, and notes that the reasoning advanced by the previous GSD administration for their withdrawal of their defense of the case, namely that they were allegedly unable to locate their allegedly star witness, Ms. Isabella Tosso, previously the Chief Executive Officer of the then Social Services Agency, without whose evidence they said they could not proceed, have been demonstrated by the inquiry to be entirely false, and which excuses the House resolves were blatantly hollow and designed to avoid a full hearing of the Industrial Tribunal case, to ensure that the allegations made in the witness statements referred to in the terms of reference never saw the light of day. Notes that had the spurious and purely technical defense succeeded, the consequence would have been to greatly reduce the level of protection against unfair dismissal afforded to workers in Gibraltar since 1974, condemns the previous GSD administration for their attempt to reinterpret employment legislation with spurious and technical arguments, notwithstanding the advice that there was virtually no prospect of success, commends the government for having commissioned the inquiry and publishing the report in full, and now calls upon the government to go further and publish the transcripts of the hearing also in full on the government's website. And I think, Mr. Speaker, there is a typographical error in the motion which should read, notes in the first notes paragraph, just under paragraph 4, notes that the report has confirmed that there were instances of mismanagement, misconduct and malpractice, and it should say there in brackets, including abuse, which is what the report says, including abuse, at the Dr. Giraldi home, which is exactly, Mr. Speaker, as you will note, and I'm now speaking on the amendment, was the first conclusion of Chairman Parker, Mr. Speaker, which I referred you to a few moments ago, but to which, surprisingly, Joanna Hernandez's first lawyer had not referred you to, which was this, where he said, Mr. Speaker, my journal conclusions are as follows. There were some instances of mismanagement, misconduct and malpractice, including abuse at the home. That's page 667 of the inquiry report, Mr. Speaker. So we've been very faithful to the findings of the Right Honourable Sir Jonathan Parker, QC, the chairman of the inquiry, in drafting this, this motion, and we are therefore proposing to the House that it should adopt a motion not in the shorthand terms that the Leader of the Opposition obviously wrote his when he thought he remembered what the Espejo Público report had contained, when he might have thought that it contained defamations, when in fact it contained things which the inquiry has demonstrated were true, when he might have thought that Gibraltarian politicians went to Spain, when in fact they didn't go to Spain, they were interviewed here, when he might have thought that they said things which were defamatory, when all they said was exactly what they were saying here, namely that they'd been seeking that the matters be dealt with and they could not understand why. All of that, Mr. Speaker, means that this motion actually properly and accurately reflects the position, and the self-serving motion which the Honourable Member brought and has been pursuing for some time now is simply designed to try and garner some public support for him and his party, which is not otherwise really rallying in any way. And so, Mr. Speaker, speaking now on the amendment, I would commend the bill as amended to the House. Sorry, I would commend the motion as amended to the House, and will now allow others to speak on the amendment at your discretion.
The question which I am now required to propose is that the amendment be made, that this very lengthy amendment be made, and honourable members may speak on the amendment.
I have been provoked to rise to my feet again.
You're so easily provoked.
Well, this only by the truth and falsehoods. Mr. Speaker, look, it's not just because it's an ungodly hour of the day for the House, you know, for sort of 19 grown-up men and women to be conducting proceedings of this sort. Not just for that reason am I actually quite indifferent about the content of this particular amended motion. I'm also indifferent to it because you know, the government is going to use its political majority to secure the passage of whatever it wants for political effect. They will all vote for it, and one thing is clear, and everyone listening to this debate will know, is that the government's political majority does not define truth. And because the government's political majority does not define truth, they have a pen, they have a piece of paper in blank, they have the majority of votes in this House, and therefore they can write on the piece of paper entirely what they please, and that is what reflects my level of interest in what is said in this piece of paper. But having said that, and recognizing that in a sense, that which I have described has always been so in the case of political majorities and political minorities, and recognizing that in the past I have used political majorities to pass motions that I wanted passed and to defeat motions that I wanted defeated, I like to think that at least when I was amending motions, I may have been expressing value judgments and opinions, and assessments with which my political opponents disagreed, but I have never consciously written on a piece of paper to have it delivered by my political majority a statement of fact which is self-evidently false. Mr. Speaker, the paragraph at the bottom of the first page, which the Honourable the Chief Minister describes as properly and accurately reflecting the position, is self-evidently false. It is as true as saying that the planet is a cube and not a sphere. But of course, they have the political majority to pass in this House a piece of paper that says that the planet is a cube, if that is what they want to do, but no one is going to believe that the planet is a cube, simply because they use their political majority to pass it. Look, Mr. Speaker, this House notes that the reasoning advanced by the previous GSD administration for their withdrawal of their defense of the case, namely that they were allegedly unable to locate their allegedly star witness, Ms. Isabella Tosso, previously the Chief Executive Officer of the then Social Services Agency, without whose evidence they said they could not proceed, the next words are the key, have been demonstrated by the inquiry to be entirely false. Mr. Speaker, Mr. Justice Parker has found, declared and stated precisely the opposite of that on that very question. So far from the inquiry having demonstrated that the reasoning advanced by the GST administration and its justification for the delays were false, he has found that they were true, that they accepted the reasons for it, and they had nothing to do with delay. Now, of course, the honourable member can invent and fabricate this statement of fact and get his allegedly independent thinkers, who are not subject to any whipping, all coincidentally to come to the same conclusion that Lord Justice Parker said the opposite of what he said. He can do that, but he should not delude himself into thinking that he can rewrite the findings of Lord Justice Parker on this point. Look, Mr. Speaker, the honourable member, I'm sure, is when he wrote this paragraph, he may have had in mind the finding of Lord Justice Parker about the lady whose name I don't now forget, about having the emails with the loves and kisses at the bottom. And he may have in mind, when he wrote this paragraph, the fact that there was an employee in the authority who, contrary to what the government knew or thought, was actually incapable of being in contact with her. But the honourable member is not entitled to attribute that knowledge of that email address and that contactability to the GSD previous administration. Still less to use that misattribution of whatever may have or may not have been known to Ms. Gomez, to me, to then reverse what Lord Justice Parker has in black and white said on this very issue. Now, Mr. Speaker, I am now going to sit down and I will wait here politely till this House votes on this motion. But with the statement that this House, if this House passes this amended motion in these terms, it will be noting something which honourable members know is not true. It is not true that Lord Justice Parker found this.
Any other honourable member wish to speak on the amendment? Mr. Bossano.
I will address the point that has been made by the Honourable the Backbencher in due course in what I'm going to be saying. Can I just say, before I start on what I had planned to say, Mr. Speaker, that when he studied philosophy, the honourable member opposite clearly didn't study Machiavelli, because I assumed if he read anything there, he read The Prince, because it's the only one that is translated into English, really, and not the whole of the works, which I did. And I can tell him that nothing that he attributes to Machiavelli was ever said by Machiavelli in Il Principe or in any other of his writings. The essence of the concept of being Machiavellian, which has entered into the English language, was because Machiavelli advised the employer that he had, who was the prince of the particular independent republic where he lived, that as an approach to dealing with people who had been his enemies, that if you have a wounded enemy, you either convert him into a friend or you finish him off. Now, that might appeal to some people or it might not. I can think of at least one person in this room that I think it would appeal to, and it's not me, who used to polish off enemies and never leave them alive to come back another day. But I'm not going to amend the motion to include that.
Stop complimenting.
So, to get back to the amendment, I am speaking, in fact, on the part of the amendment that deals with the condemnation of the administration for their attempts to reinterpret employment legislation, which of course is not factually in doubt. I mean, they did attempt to reinterpret it, and whether one should congratulate them or condemn them is what I'm going to see if I can persuade members opposite of. First, I think I owe to the leader of the opposition, Mr. Speaker, need to express my gratitude to him, because he's given me, by bringing the motion in the first place, the opportunity to put in the public domain and on the record of the Parliament the issues that I would have been able to air had the hearing of the Industrial Tribunal proceeded, or if I'd had the opportunity of addressing this issue in full before the inquiry. As has been mentioned, the original termination of employment, or the indication of the termination of employment of the manager of the home, was contested by the leader of the opposition. Yes, the leader of the opposition challenged that decision as the lawyer of Joana Hernandez, and the letter.
Speaker, is he now speaking on the amendment, or is he now responding to me on the amendment?
No, I am speaking on the condemnation of the decision to attempt to reinterpret employment legislation. And in order to go through the wrongful actions of the previous administration, I have to start by explaining the sequence of events which start with him. That is to say, when he started off in October 2005, he was opposing the dismissal and saying it was a fair, even independent of any consideration of this esoteric invention that came along later of the 53-week year, to which I will address myself later on. Originally, what the honourable member opposite, the leader of the opposition, was arguing was that in fact the termination was procedurally wrong and unfair, irrespective of anything else. And he argued, in fact, something that Mark Isola was also arguing when he took over the case in the advice he was given the government. We start off with a situation where the honourable member was involved initially in October, and the position that he took up to the point when the chief executive officer on the 24th of October wrote a letter saying probation and confirmation of appointment. I am writing to inform you that your performance in your position as a manager of Dr. Giraldi Home has been reviewed, and it is the conclusion of the Social Services Agency, not my conclusion, the agency's conclusion, that you have failed to meet the required standard. Not true. Not true. Because in fact, what the government said subsequently was that she was a star witness because she took the decision on her own and without consulting anybody else. Now, I don't know whether that was legitimate for her to do, but she claimed that it was not her decision. She claimed in writing to the person concerned, it is the conclusion of the Social Services Agency, and that suggests that it's the conclusion of more than one. Indeed, it suggests that it would have been something that had gone up to the minister and up to the board level of the agency. Because we're being told that we cannot hold the government responsible for what Mari Gomez does. Well, look, Isabella Tosso holds the Social Services Agency responsible for what she did. But of course, at the time, the position of the honourable member was to reject this. He said it is clear that Mrs. Nandes has been treated unfairly in the procedure followed for her dismissal, given the timing of the letters and the lack of reasons supplied. Given the circumstances, we have come to form the view that this unfair treatment towards Mrs. Nandes has come about because of the investigations that Mrs. Nandes has been carrying out into aspects of running the Dr. Giraldi Home and the complaints made against senior members of the staff. It appears that the agency has chosen, instead of dealing with the problems voiced by Mrs. Nandes, to avoid matters and turn them against her. This victimization is clearly unwarranted, given that Mrs. Nandes was merely dealing with numerous complaints raised by staff under her management. Excuse me, Mr. Speaker, is this signed Joe Bossano? No, it's signed Danny Fitam. Then I can't believe this. I mean, should I condemn the member opposite?
No, publish it.
Do I say this is hypocrisy and double standard? Is he guilty when he does it, or innocent, and I'm guilty when I do it 3 years after him?
Shame.
This is the letter signed by the honourable member on the 14th of November 2005. And he says that he's come to the conclusion that the reason why Mrs. Nandes is being victimized is for whistleblowing on the complaints of all the members of the staff. But wait a minute, didn't she fabricate these things? Well, I agree with him. He's right. He was right then, but he's wrong now. Because I was saying that then, and I am saying it today. And that is the difference. It's no longer GSLP. So it doesn't say the same things 2 years later. When he said that, he was defending exactly the same thing that we have been defending all the time. And if indeed he believed what he was saying when he signed it, and he believed that the agency had chosen, instead of dealing with the problems voiced by Mrs. Nandes, to avoid matters and turn them against her, then in fact he must believe, as we do, that this was a case of victimization for whistleblowing. Unfortunately, unfortunately, at the time, the victimization of an individual for whistleblowing was not included in Gibraltar, although it had been in the United Kingdom since 1998, as an area which required no minimum level of service. If this had happened in the United Kingdom, the case would have been heard immediately, because under the United Kingdom, if you are exercising what is a duty, which is to report what you genuinely believe to be wrongdoing, you cannot get sacked because it's less than 52 weeks or 53 weeks or any other number of weeks. You can have been working 1 hour and you're protected against unfair dismissal. But unfortunately, the GSD in 2005 had not attempted to bring the laws of Gibraltar up to the standard of the United Kingdom of 1998, which they should have done when they came in after 1996. So instead of being a progressive administration that protected workers that were whistleblowing, they took advantage of the fact that they were a regressive administration, and, as it clearly pointed out to them, they went on to victimize Mrs. Nande and to compound the felony, Mr. Speaker, to compound the felony by, first of all, the first argument, as I tried to explain to Chairman Maopaja, I tried to explain this to the Chairman, but you won't find it there. The first argument which was put, which was at the time when the case was transferred from my colleague to me, which was the first time, by the way, that I met this lady, and he had known her for many more years than I had and held her in high regard. And I only was given the responsibility for handling this for a very simple reason, which was a reason that I explained to the tribunal, where I said I had reason to believe the pressure had been put on the union. Mr. Speaker, following this exchange, there was a letter signed by my colleague informing the union that he had now received the files from the honourable member opposite, and that was 4 days after this, on the 29th of November. And the union had a policy in place where, before they gave legal support, they had to have an evaluation which required that the lawyer was able to recommend that the case should proceed on the basis that he considered that there was more than a 50-50 chance of winning it. The evaluation done by Hassan's came back saying the chance of winning it is over 70%. And the union, having first said you have to do the evaluation, then said we cannot finance it because the evaluation has been too expensive. Well, look, it's totally insane if the policy were that, first of all, you require that somebody does an evaluation. If the evaluation comes out under 50, you don't get the support of the union. And if it comes out over 50, you don't get the support of the union because the evaluation has been too expensive. Well, then you wouldn't get the support of the union ever. But of course you get it all the time, because this is the one and only case when it has happened. Never before and never since. So we start from the very beginning with singularities, as if we were in outer space. A singular attempt to silence somebody, a singular interpretation of the support from the union, and the indications from the union were that continuing to provide finance to defend this case would mean that it would be seen as a hostile act by the administration. Okay? So in fact, the regime at the time It was similar to the one of our neighbor, where if you are nice to the Gibraltarians, then that is seen as a hostile act by the junta in Madrid. And therefore, the junta in number 6, Common Place, behaved in the same way. And they said, if you support somebody that is going to go against me, then we will bear that in mind. Of course, I couldn't produce the evidence, because if the evidence that is required to convince the inquiry is that somebody's got to admit to that, then it will never be possible to produce the evidence. But I can tell the House what kind of evidence there is. And the kind of evidence there is that having said they could not continue to support her, they called me up and asked me to take on the case for free. I took on the case at the request of the union, not at the request of John Hernandez, who didn't know me and I didn't know her. It was the union that sent her to me and said, look, we cannot do it because this is going to affect us in our relationship with the government if we are financing a case against the government which is controversial, and therefore can you take it on? In the past, I had normally taken on cases given to me by the union, not because the union said they wouldn't finance it, but because the lawyer had said to the union it didn't stand more than a 50-50 chance of winning. And I won them all, even though it was less than 50%. So when the union said, if it's a lost case, send it to Jobosano. If it's not a lost case, we'll let some lawyer make money. That was really what it amounted to. Okay? Yes, well, I suppose. So from that time on, Mr. Speaker, I want to take the House through the sequence of events which justifies the condemnation in the amendment of the way this was handled by the government. Having started with the tribunal, the first thing that happened was that the Attorney Generals contested the case on the grounds of jurisdiction. That is to say, they sent a letter back to the tribunal saying there is no jurisdiction to hear this case because it doesn't meet the requirement. And they argued initially, I can't understand how they did, but they did argue initially, the absurd proposition that the requirements of the law were not being met because notice had been given in October. And therefore, the termination of the contract was on the day that the notice was given and not on the day the notice expired. So they argued initially that the employment had lasted 11 months. The law is absolutely clear. The law says in the Employment Act of Gibraltar that the termination of employment happens on the date the notice expires, not on the date the notice is given. And on that basis, that argument was shot down at the first hurdle. The next step, therefore, was that the Attorney General chambers were told to hand over the case to a private lawyer, and it was initially, I've just found out as a result of the inquiry, being offered to Mr. Dumas, and then because it was not available, it was offered to Mark Isola. And Mark Isola was asked to find another reason for challenging the jurisdiction, because the original reason didn't work. And he came up with this concept that there was case law in the United Kingdom to justify what was being done. Well, this is a disgraceful attempt by the GSD government, which no trade unionist sitting in their ranks should be able to defend or live with. Here we have a situation where the government of Gibraltar, that has been in power since 1996, turns around and says to its lawyer, find me a reason for stopping the hearing. And the lawyer has got a job to do, which is a tough job. He said, look, this is going to be very difficult. The chances of getting away with this are minimal. And that is in the correspondence. And this goes all the way to the chief minister, who was the one insisting on it. He came up with some ridiculous argument that it was something to do with the Gregorian calendar, and that there used to be lunar calendars before and not afterwards. All this was done in public, because the argument was so ridiculous that I make the point of ringing everybody up in the press to come and listen to this. This was a real circus. Then he produces one case, Pearson in Scotland. And Pearson in Scotland had ruled by a majority of 2-1 that somebody was not able to meet the test of jurisdiction at a time when Scotland had a requirement for 26 weeks. And the argument of Mr. Isola was, because of this case in Scotland that didn't meet the 26 weeks, we should apply that to the 52 weeks. But the case in Scotland was that they were trying to argue that the week should count whether it was 7 days or just 1 day. And in fact, the Pearson case, which was from the 1970s, the argument of the claimant was that although he had worked 25 weeks and 2 days, the 2 days which were a part week should count as a full week. And that was lost because it did not meet the 6 weeks. It had nothing to do with starting on Sunday or finishing on Saturday. It was about whether on a consecutive basis there were enough days to say it was 26 multiplied by 7. And the answer was it wasn't. This is then converted into an argument that in the United Kingdom there is a definition of week and a definition of year and a definition of month, but in Gibraltar there isn't. So the government of Gibraltar comes along and says, we've got a problem because the law was changed in 1974 in UK. And I say, what law? Well, they cannot produce what law. They say, well, look, there are plenty of examples in the UK. I said, cite them. They can only cite Pearson in Scotland. I say, well, look, in Gibraltar we've had this law since 1974. Mr. Speaker, it was your law.
I'm not surprised. You realize what you let yourself in for.
It was your law. And when you brought it to the House, following a question that I put to you, you said in the House in 1974 that you are going to protect people against unfair dismissal if they worked 2 years, which was what had been done initially in the United Kingdom. And you argued with me that, I don't know whether you remember it, but I do. You do? Good. Then you told me that although you were doing it for 2 years, when I tried to persuade you not to do it for 2 years and to do it for 1, you said, okay, well, look, what we will do is we'll put in 2 years. And if in 12 months' time you come back and you demonstrate that there hasn't been an avalanche of complaints which has choked the system, then I agree that we will amend the law and reduce it to 1 year. And that is precisely what happened. And in 1975, you reduced it to 1 year. That is to say, you said in Parliament, I'm going to make it 1 year. But the regulation that came out published by the draftsman didn't say 1 year. It said 52 weeks. And the regulation in 74 didn't say 2 years. It said 104 weeks. And now we have somebody coming along 30 years later saying that the law was unclear. Wait a minute, the law that everybody has been abiding by for 30 years unclear. So I said, let's go back to the Hansard. Let's find what was the intention of Parliament. Was it the intention of Parliament that you were protected if you worked 1 year and the year happened to be 53 weeks long? Well, then that would never happen. There are no years. There are leap years which have got 1 more day, but there's never a year that has got 53 weeks. However, if the 1st of January is a Sunday, and the 31st of December is a Saturday, then that year counts, because that is a year of 52 weeks, beginning on Sunday and ending on Saturday. It is that level of absurdity that was used, which the chairman of the tribunal said, well, look, I've never heard this before. There is no evidence anybody has argued this before, but fine. I don't think this is fair, and I am ruling that it shouldn't be used. And what does the government do? The government says, well, we're going to appeal to the Supreme Court. Now, the Supreme Court at the time still had Chief Justice Scofield. They hadn't bundled him off yet. So I suppose that helped to introduce some common sense into the appeal. And he, in fact, I was not able to go to the appeal because you have to be a lawyer to be able to do that. Yes. My colleague Gilbert was the one that took the case to the appeal. And although he went very well prepared, in fact, the Chief Justice said to him, look, you don't even need to say anything to convince me. This is so ridiculous an argument that I'm telling you now, I'm throwing it out. And all that we need to say, how could anybody with any background of defending workers, how could anybody argue that there could be a system where you get a letter that says you are here for 1 year's probation, all right? You start on Monday, I then sack you in the 52nd week, and I'm telling you, although it's a year, it's not 52 weeks, because I commenced your contract on the Monday. And in order for you to have 52 weeks, I should have commenced your contract on a Sunday. And they do this to an employee that was already in the public sector, in the education department on the Friday. So she finishes on the Friday, and she starts on the Monday, and she doesn't work on the Sunday. And that is the basis of the government's argument for saying there is no jurisdiction. And they fight this case in the tribunal, in the Supreme Court, and in the appeal court. And this is not a plot to stop the tribunal hearing. No, this is they tell the tribunal, the inquiry, this is to clear up the confusion that might be about the law says. So the chairman says to me, well, would you agree that it's necessary to clear up the uncertainty about what the law means? Well, there is no uncertainty. I mean, the law's clear. It's been clear for years. They then produce as an argument that they have consulted a QC in the United Kingdom. And the QC in the United Kingdom has told them, well, look, it's not impossible to win. Well, of course it's not impossible to win. It'd be a miracle if you won. And miracles presumably sometimes happens, or the guy has fallen asleep and hasn't had the arguments and gives the wrong decision. So it's not impossible to win, but it's highly unlikely. But if there is doubt that needs to be cleared up, then the government may want to test it so that the law is clear for the future. Well, of course, the guy that is giving the advice, the QC in the United Kingdom, a Mr. Barr, yeah, Mr. Barr, I don't know who he is, says, well, look, if the government feels that there is a need not to win the case, not to stop the allegations, not to stop these things, no. If the reason for wanting to do it is that there is uncertainty about the meaning of the law, then, although in all probability, what the result will be is that it's 52 weeks made up of 7 consecutive days, which is how everybody has been doing it since the year dot. If you think there is uncertainty, you want to clear up the uncertainty, then by all means. The only justification that the QC gave, according to the evidence in the inquiry, which I didn't know before, was that he justified it as a very long shot but justified by the need to clear uncertainty. And then, when Chairman Parker said to me, well, after hearing this, do you change your mind? I said, no, I don't change my mind. I'm more convinced now than before I heard it. Because if the QC has been told the reason we want to go ahead is to clear uncertainty, then the QC has been misled in the brief that is had from the government, because no uncertainty has ever existed, and because the lawyer they contracted, Mac Isola, was constantly telling them, you're going to lose this. You're going to lose this. Stop wasting money. Either let's reach an agreement and settle, let's offer a settlement, or let's have the hearing. Now, having delayed the system by doing this, allegedly not for any deliberate motive, just I suppose because the chief minister, the former chief minister, told the court, well, why do you do? Well, I just felt like having another shot. You know what I mean? Just for kicks with the taxpayers' money. Well, I can tell the honourable member that when he had the first kick, which was going to the appeal court here, I took the matter to the union. And here I've got in February 2007, the letter written by the district officer, Charlie Ciccarello, to Fergus Whitty, the head of the legal services of the UK. Thank you for your letter and helpful advice. We have no doubt, says the union, that the government's lawyers are wrong and that they know it. This is not, these are not the Tupamaros in the GSLP. This is Charlie Ciccarello, highly regarded by the government. At least at some point. He was sent to Coventry for a number of years, and then they brought him back into the fold. So the union says we have no doubt the government's lawyers are wrong and they know it. So it's not that they have doubts, they know they're wrong and they're deliberately stopping the tribunal from taking place. The legal firm, the union says, is the legal practice of the father-in-law of the chief minister, Mr. Caruana. Horrendous language, mentioning the father-in-law. I mean, don't mention fathers or cousins or brothers. They have been instructed by the government to appeal. The case was originally in the hands of the Attorney General and was briefed out to 3i and 3i. And we believe this to have been a political decision. The law in Gibraltar does not require 1 year's continuous employment, but 52 weeks. The argument used by 3i in the tribunal was that whereas the law in Gibraltar gives a definition of a year and a month, which is the same as in UK, it does not define a week. He argued that in 1974, UK employment law defined a week. Not true. As a 7-day period from Sunday to Saturday. Not true. And that by virtue of this definition, the 52 weeks of continuous employment had to be counted commencing on Sundays and ending on Saturdays. This means that someone whose contract of employment started on Monday would not count the first week. And if the employment terminated on Friday, would not count the last week. So the guy's got to do 54 weeks in order to have 52. Joe Bossano won the argument in the tribunal for one of our members, but cannot appear before the Supreme Court. It's not because I'm persona non grata, it's because I have to have a legal qualification. And if we do not contest the appeal, it could be lost. The fear was that the appeal uncontested might be lost, and there would be serious consequences, not just for this individual, but for the entire workforce. And that's why the amendment condemns the government. And that's why all the nasty things that the mover of the motion said, he should now be saying about the decision to delay and the decision to attempt to reinterpret the law of Gibraltar from the way you introduced it, Mr. Speaker, from the way that every single lawyer has operated it for 35 years, and from the way that the honourable member opposite was advising Joanna of her rights when he was a lawyer. So how can he defend the opposite of the advice he gave her when he ceased to be a lawyer? The union told the head office, we believe the whole strategy is to try to delay the case being heard until after the general elections. Is there political motivation here? Is this a conspiracy? The chairman of the tribunal says there is no evidence. Would this constitute evidence? Well, no. If he doesn't believe me, why should he believe Sally Citarello? If they called Sally Citarello back from retirement, would he still say what he said when he signed this? I don't know. But I can tell the honorable member one thing. I didn't make this up. The union says our member was employed in the civil service for over 5 years, finished work on Saturday and started the work on Monday in the Giraldi home. The appointment was subject to 1 year probation, and the union had a pending claim for continuity of employment given that the social services agency is part of the government public service and half of the staff are civil servants. The union had a claim for continuity even on that ground alone. What are you talking about? 1 year and 52 weeks. This is year 6. Our members received reports of cases of abuse of the persons in care and reported this to the chief executive, and copies of the reports were sent to the minister. The union saying all this. The act of whistleblowing, we believe, was a real reason why it was claimed that she had failed to meet the standard required in the probation year. So now the union agrees with the leader of the opposition and with me, because that's what I was saying then, and this is what I'm saying now, and I am being castigated for saying what he subscribed to and the union subscribed to. Well over a year ago, her employment was terminated from November 2005, and we are still fighting to have the case heard, says the union. We have a long list of witnesses with sworn statements. Where are those the ones you fabricated? Or did I fabricate them? Or didn't the union know that they were fabricated? Long list of witnesses with sworn statements, both as to the high standard of our members' performance and as to the complaints of abuse of disabled children and adults within the service. The approach to the government or the lawyers that you suggest, because the head officer, why don't you try and talk to the employer, to see if we can find a settlement, rather than fight it in court and having to go to an appeal and spend a lot of money. The approach to the government or the lawyers that you suggest is pointless, since the government is willing to spend whatever it takes to prevent the facts coming out. I will send you the transcript of the argument used in the tribunal as soon as they're available, so that they would frame it as, you know, a unique event in legal history dealing with the Gregorian calendar and the 54-week year. I enclose the ruling made by the chairman and the notes taken by Joe Bosano of the statements made by the lawyers. Local lawyers are confident that the application can be won and presumably should be able to get costs awarded, but we need the appeal. The union needed the appeal, not just because it was grossly unfair what they were doing to the member, but because it meant that what the government was prepared to do, as their lawyer Mark Isola told them in the documents that are now public, was take the risk that if they won, which was considered to be highly unlikely, if they won, immediately after winning, they would then have to come back and legislate to make sure that they didn't deprive everybody else coming after this particular case from their rights to unfair dismissal. So here we've got evidence that there is no fabrication, evidence that there are real statements, evidence that it's not a GSLP, or is it that we had the TNG in our pocket in 2007? The 2007 was driven by the 2007 election date. That's why that was this important. The Supreme Court ruled in favor, and we were awarded costs, and therefore, as far as the union was concerned, that is what happened. When the government said that they were now going to go one step further and take it to the Court of Appeal, the union at that stage said, look, the head office thinks that, given that their own analysis was that the government is willing to go to the House of Lords if need be and spend whatever it takes to stop it happening, the union was told they would call it a day. Well, Mr. Speaker, even at the start, on the 25th of October, when the leader of the opposition was representing the manager that had been told she would be terminated in a month's time, the minister, Yvette del Agua, was given a letter by the parents of the users saying the following: it is with much regret that we have learned that the Social Services Agency will not be renewing the contract of Joana Hernandez, current manager of the Giraldi home. The families of the users of the home are therefore decided to show their support and condemn the decision not to renew her contract. We find her a very dedicated, professional and qualified person and are very concerned that this is the fourth manager in a row of Dr. Giraldi home that has been replaced in as many years. This wonderful house that the honourable member opposite, Mr. Neto, has told us of the great, the quality of the place. Well, look, they sack managers every year. They brought one manager in, he lasted 1 year and he went. 4 years for managers. And it was always the fault of the manager, never the fault of the minister. We believe that there are inherent problems within the service, and these problems have caused the loss of several professional and dedicated members of staff over the last few years. With this in mind, we wish to publicly voice a call for an independent inspection into the local residential services by the Care Standards Commission from the UK. This is at the beginning, when the honourable member opposite was representing her, before anybody in the GSLP had called for anything, before the termination had taken place. Did the government, because this is the government, this letter is to the government, did the government say, well, look, let's take a step back? After all, these are the parents asking us now. This is not the opposition. The opposition was not involved. Why not go to the Car Standards Commission in the UK? Or is it that you only go to UK to download their stuff, copy paste it and claim it's yours? That's the degree to which you're interested in UK. Well, I can tell you, Mr. Speaker, that in terms of what has been done, the evidence before us is that there is justification for what the amendment says. Because the other element that has been mentioned, which is the element of the access of the government to Isabella Tosso, is something that I can also demolish. Not only is there a situation where in October 2007, the letter from Isabella Tosso to Mari Gomez was, my dear friend, I'm writing this, no wonder you have been feeling as you have. This was because Mari Gomez here was saying what a rough time she was having with Wilson, who had been put in charge. And she says, I cannot wait to see you on Saturday when I can give you the hug that I am sending you now. On Saturday in Cadiz. She was supposed to be in New Zealand. That's what they told me in the tribunal. We cannot get hold of Isabella Tosso because she's told her she may not be in Europe at all. She may be in New Zealand and we think she's in New Zealand. But look, wait a minute. Your manager, the one that replaced her in the tribunal, the person that was going to be given the evidence, their second star witness, they decided the star witness couldn't be found because she was supposed to be in New Zealand, but she was in fact in Cadiz, was going to be replaced by Mari Gomez, and Mari Gomez was going to be delivering the devastating blow that would prove that all the witness statements were all false, that here we had a lot of people who were all going to be committing perjury, and that the manager was useless. And Mary Gomez forgot to tell anybody until these emails appeared in the tribunal, forgot to tell anybody that she was going to go to Cadiz to meet Isabella Tosso. And Mark Isola was telling me in the tribunal that she was in New Zealand. Well, there was a postponement while we waited for her to come back from New Zealand. And eventually, after the postponement, the next step was to argue that she could not be contacted. And when they said that they could be contacted, they said that it would carry on first with the new manager, and then they changed their mind and they said Mary Gomez would be delivering the case for the government. The day we sat down, because we actually sat down to start, and the day Mary Gomez was supposed to make the opening speech to meet the burden of proof, Mr. Isola told the chairman that the government had decided that the burden of proof could not be met by the contribution of Mary Gomez, and that instead what they were doing was saying they could not produce the evidence that would show that the dismissal had been fair. And I said I wanted to carry on. The chairman said I couldn't. And I said, but I know where she is. I can tell you where she is. All you need to do is Google Isabella Tosso, and since there is a register of workers in the United Kingdom, because I've done it, they will tell you her telephone number and her number. Now, look, I may not have, Mr. Speaker, evidence that could win a conviction in a court of law. Court of laws are mysterious places that I do not understand. And the guys that wear wigs and sit in them, I understand even less. But I can tell the members opposite that if they genuinely believed what they said at the beginning, I hope they have stopped believing it by now. And let me tell the honourable member one final thing. At the beginning of the saga, when the letter was sent telling her your contract may not be renewed in September, the letter from Isabella Tosso said your contract may not be renewed. The tribunal was told that the letter had said your contract will not be renewed. That was a lie. It said may, and may means if you improve the performance, it may not happen. But it was worse than that. It was worse than that. Because the letter said, I have consulted the labor inspectors, and they have told me I can go ahead and not renew your contract. And when I got this, because I asked for discovery, and the evidence from the correspondence between the lawyer and the agency shows, and the honourable member opposite, Mr. Neto, was a recipient of some of this correspondence, shows that the advice that he was getting was, you're going to lose this, because on procedural grounds, you've lost it, as indeed the leader of the opposition had identified in day one. And even if it's not on procedural grounds, you're on very sticky ground. You better find a way of solving this one. Look, there are two options that they chose not to do, for which there is no explanation. They chose not to attempt to reach an agreed conciliation. No attempt was made to do that. And secondly, no attempt was made to say, well, look, if you are genuinely in your concern, let's have the investigation in a way that is transparent and that people can be satisfied. But what happened from the beginning, there are lies, because when I get into the picture and I get that letter saying the labor inspectors have been consulted. I knew they were lying. I knew they were lying because I've been dealing with these things all my life. Labor inspectors don't give advice to employers how to sack people. Labor inspectors listen to the people who are sacked and advise them. So I insisted on the evidence, and eventually, when all the appeals had been exhausted, which was 3 years after the termination of employment, Mark Isola accepted that I had a right to discovery and sent a letter to the director, Ernesto Gracia, and he said, we have been instructed by the agency to write to you inquiring as to whether any of the labor inspectors at the Employment Service has any recollection of Isabel Atosso, the chief executive, making an inquiry or otherwise in September 2005 concerning a member of our staff, one Joanna Hernandez, and in particular whether you have any record of it. The answer is no. The Labor Department writes back and says, no, I can confirm that none of the labor inspector has any recollection of ever having spoken to Isabel Atosso, the chief executive. From the beginning they were lying, and they've been lying throughout. And it's not just me that says it, it's the union that says it, and it's the parents of the users that say it. And therefore, Mr. Speaker, I commend the amendment to the House because what it says is accurate. And if Chairman Parker says there is no foundation in my thinking there is a conspiracy to prevent the truth coming out or to prevent the proper protection being given to workers, and if any government goes to the length of putting at risk the protection that has been there for 30 years for 20,000 people for the sake of one case, look, there's something there that doesn't make sense. There is an absence of logic in this that doesn't make sense. And I have to say, well, if somebody say that there is no foundation in anything I am saying, here is the foundation. And I will be judged by the electorate, by the people who put me in this house, and not by the chairman of an inquiry.
Order. Does any other honourable member wish to speak on the amendment? And then I will call upon the Chief Minister to reply if he wishes to do so.
Mr. Speaker, thank you very much. I do have to deal, I think, with, despite the late hour, with the issue that the backbencher raised. He's not here to hear me respond, but he raised an issue before he left. Mr. Speaker, the backbencher talked about us simply using our political majority to pass a motion that did not reflect reality. Speaker, for all the reasons that the Father of the House has demonstrated, that is not what the amendment reflects. But there is one particular aspect of that which I want to deal with specifically. Because the Honourable Mr. Katana referred us to the words, have been demonstrated by the inquiry to be entirely false, and followed up with saying, but Sir Jonathan Parker did not find that. Sir Jonathan Parker did not say that. So you're going to make the motion say something that you are saying the inquiry found, which Sir Jonathan Parker did not say. Of course, Mr. Speaker, that is why the motion does not say, as demonstrated by the finding of Sir Jonathan Parker. It says, as demonstrated by the inquiry. Because, Mr. Speaker, and he was absolutely right when he said that this is what I would refer him to. The evidence of Mary Gomez, as it's headed, part of the evidence of Mary Gomez, and pages 656 to 657, deal with this issue. And the inquiry makes a finding that Ms. Gomez was misleading in the answers that she gave about that subject, and she was, in fact, in touch with Isabel Atosso. And the Honourable Father of the House has gone through that in greater detail than I need to go through the rest of the House with that, because he's shown us the business of her being said to be in New Zealand but actually being in Cadiz, etc., which demonstrates just how lacking in candour the government was in the way that it was dealing with this matter. But the important thing is that the motion specifically does not say the finding of Chairman Paca, but it actually says have been demonstrated by the inquiry to be entirely false. And there was a reason for that, because in that way, Mr. Speaker, the motion is absolutely right. Not because we're going to say that the planet is a cube when it is a circle or a sphere, but because, Mr. Speaker, this is a Rubik's Cube that the Honourable backbencher is responsible for having muddled up, and we are ensuring that all the colours will show only on, each of the colours will show only on one face. Mr. Speaker, the only other person to speak on the amendment was the Father of the House. I have to tell him he does not like to hear positive things about him. He'd rather hear something negative so he can come back and attack. That's him all over. But he has demonstrated tonight in the speech that he has given now why it is such an honor and a privilege to serve with him, Mr. Speaker. He has been able not just to extract from the findings of the inquiry and the documents before the inquiry the facts which are salient and which are important that the public should understand, but even more important than that, in a way that even the most uninitiated will understand, he has demonstrated the duality and the duplicity for which the Honourable the Leader of the Opposition is becoming known. And he has demolished, at the same time as he has completely dismantled, all the reasoning behind the original motion, and in that way lent credence to the need to move the amendment in the way that it is drafted, because he has shown what I sometimes say in a way that is going to be instructive to whoever wants to understand how to demolish a political opponent. He has demonstrated that the honourable gentleman opposite flip-flops from one position to another, but he made the cardinal mistake, Mr. Speaker, of putting a motion dealing with a matter that Joe Bossano was dealing with, which is totally contrary to a letter that he signed 10 years ago. And Mr. Speaker, I dare say, it's that amnesia again. He wrote the motion, Mr. Speaker, forgetting that actually he'd written the letter. And Bossano, Mr. Speaker, Joe Bossano was more than just masterful. I think he has demonstrated that whether he likes it or not, he has more than just the qualities to be admitted as a member of the bar in Gibraltar, not as a junior. Not as a junior. At least, Mr. Speaker, not as a junior counsel, Mr. Speaker, not even, Mr. Speaker, as a QC, but as the Honourable Mr. Neto said of Mr. Carron a few moments ago, as a QC. Because his speech this afternoon, this evening, tonight, Mr. Speaker, has been a veritable tour de force, Mr. Speaker, a veritable tour de force that will be read by future generations of Gibraltarians as an example of logic and how to pursue a duplicitous opponent and demonstrate just how his duplicity has affected the attempt to mislead the House that we have seen with this motion. Mr. Speaker, there is one point that I think the Honourable Gentleman has not mentioned, which came to me as he said that, in fact, the Honourable gentleman opposite, the Leader of the Opposition, had known Joanna Hernandez for much longer than the Father of the House, when she is now described as a GSLP activist that our machinery would have done anything to protect. Well, Mr. Speaker, I remembered that it's not just that the Honourable Member was her first lawyer, something he didn't want to remind us of, that he had signed that letter, which in fact accorded with the theory of the case that was subsequently advanced by all, which he didn't want to remind us of, but that he says that she's a GSLP activist. Joanna Hernandez, the GSLP activist. But I think it is also important to remind the House, Mr. Speaker, because the Honourable Gentleman hasn't done so, that in the 2003 general election campaign, the Honourable Member's Labour banner did not hang from Water Gardens, Mr. Speaker, it hung from the Bahia bar that belongs to the Joanna Hernandez family. And she was then a Daniel Feetham activist, a Labour Party activist, the one he couldn't take with him when he did the deal with the GSD, Mr. Speaker. So much for being honest about the statements that one makes. And, Mr. Speaker, therefore, his credibility in tatters. and metaphorically, politically naked before us, having cut off all his robes with his home pen with which he signed the letter in 2005. Mr. Speaker, it is absolutely right that the House should, not because we have a government majority, but because having heard the arguments so eloquently put by the Father of the House, should support the amendment to the motion. But, Mr. Speaker, if he thought that we wanted to bury the debate on this motion, as he has said before, the fact is that having heard what he has heard from the Father of the House, he must be hoping that we were able to bury the debate on the motion and not see how he has been buried by the logic of the Father of the House. Because we would have wanted everybody in Gibraltar who is going to make up their minds about how they're going to vote to hear the demolition that has occurred tonight. And from what I am seeing on social media, Mr. Speaker, they have. So we were right to adjourn to now because people have been able to tune in, they have been able to watch, they have been able to understand the difficult issues clearly and simply explained by the Father of the House. And I am minded, Mr. Speaker, once the House approves this motion, and I do commend it for approval in the amended terms, although I will not move an amendment to the amendment now because of the late hour, the government, Mr. Speaker, I commit, will not just publish and ensure that it is published widely the text of the amended motion. We will also publish Mr. Feetham's original letter of advice with it, together with the transcripts of the hearing, so that people can see evidence demonstrated, that word he likes so much, of his duplicity, simply by comparing his first letter on the subject of Joanna Hernandez with the motion that he moved today. I commend the motion in the amended terms to the House.
I now put the amendment. Those in favour?
All division, Mr. Speaker, of the amendment. Mr. Speaker, I have to respond to the original.
I will explain. We're going to vote on the amendment, and then I will explain clearly what the position is. Is there division required?
Yes, Mr. Speaker, in particular
Very
because
well.
a person has spoken on this amendment
Very well.
and then left, and I want that
Have
reflected in the
division.
minutes.
Very well.
P.J. Balvan. J.J. Vosano. D.J. Vosino. P.R. Caruana. Absent. J.E. Cortez.
Yes.
N.F. Costa.
Aye.
Isabel Hammond is absent. D.A. Feetham.
No.
S.M. Figueres.
No.
J.J. Garcia is absent. A.J. Isola.
Aye.
G.H. Licudi.
Yes.
S.E. Linares.
Yes.
J.J. Neto.
No.
F.R. Picardo.
Yes.
E.J. Reyes.
No.
S.J. Sacramento.
There are 3 members absent. The amendment is carried by 9 votes to 5. Now, I will explain what the position is now. This is now the amended motion before the House. On the government side, the Honourable Mr. Bossano cannot speak on it, neither can the Honourable the Chief Minister. All the other ministers can speak on this amended motion if they so wish. On the opposition side, the Honourable Mr. Peter Caruana, who is not here at the moment, he cannot speak on it. Neither can the Honourable Mr. Neto speak on it, because he has spoken on the motion, and this is now the motion before the House. In any case, at the end of it all, whether any other members take part in the debate or not, the Honourable, the Leader of the Opposition, is able to exercise his right to reply. So do any other members wish to speak on this which is now the amended motion before the House? If not, I will call upon the original mover of the motion, the Honourable the Leader of the Opposition, to reply. The Honourable the Leader of the Opposition.
Mr. Speaker, talk about smoke screens, contradictions and duality when we have just been treated, Mr. Speaker, over the course of, I make it 4 hours, to the largest, indeed, yes, thank you, Mr. Speaker, thank you.
4 hours and 10 minutes.
4 hours and 10 minutes of the largest smokescreen, contradiction and duality that this Parliament has ever witnessed in the two speeches by the Honourable, the Leader of the House and the Father of the House. Mr. Speaker, before I look at those smokescreens, those contradictions and that duality, multiple duality in the speeches delivered by the Honourable the Chief Minister and the Father of the House, let me deal with what are very substantial inaccuracies, Mr. Speaker, and misrepresentations made to this House, in particular by the Honourable the Leader of the House and the Chief Minister, Mr. Picardo, about my role in the Hernandez case, and indeed why it was that I stopped acting for Mrs. Hernandez. And he made a number of comments. The first one was, he stopped acting for Mrs. Hernandez because he did the merger with the GSD, and that was the reason, and what he did was left, right, and effectively flip-flop and ditched Mrs. Hernandez because of the merger. Well, Mr. Speaker, let me read from an interview that Mrs. Hernandez gave to the Panorama newspaper on the 13th of February 2009. Not my words, Mrs. Hernandez's words. And she said this: "At the end of a year and 2 days, I was dismissed, and Mr. Feetham offered to take the case to the Industrial Tribunal." That's what she says. "But I felt that it would be problematical for him since he was the chairman of the executive committee of the party in government." So it was Mrs. Hernandez, not me, Mr. Speaker, Mrs. Hernandez, who had turned round to me and said, "I don't feel comfortable with you taking the case because you are the chairman of the party in government." Mr. Speaker, my professional duties, which I take extremely seriously to my clients, oblige me to put the interests of my clients before any political interest, Mr. Speaker. And there is absolutely no question, had I been continued to act for Mrs. Hernandez, that I would have continued to act for her, Mr. Speaker. Now, Mr. Speaker, just turning at this stage, and I'll come back to other misrepresentations made by the Honourable Gentleman, but the Honourable Gentleman, the Chief Minister, has to accept responsibility for the accuracy of statements that he makes before this House. What he cannot say, he ditched Mrs. Hernandez because he did the merger, when Mrs. Hernandez herself, in an interview, says quite the opposite. I didn't. I wanted to take the case forward. But, Mr. Speaker, the Honourable Mr. Bossano, just tying it in with this before I go on to consider other misrepresentations made by the Leader of the House. He said that I had been right from day one. Well, actually, I was right from day one in relation to Mrs. Hernandez's case. Because the position that I took from day one was that the right procedure had not been taken in relation to her dismissal. And that was, well, he's divulged the advice that I provided, and no doubt he has a consent for Mrs. Hernandez for disclosing privilege in that regard. That's what he has done. So I accept that that's the position. That's absolutely right. That was my position from the very beginning, and indeed that proved to be the correct position right at the very end, Mr. Speaker. And indeed, the Honourable Gentleman may not know this. Well, probably Mr. Bossano does know this, that the reason why Mrs. Hernandez was ultimately successful was actually because of the tactics that I deployed in this particular case at the beginning. Because of Mrs. Hernandez, absolutely, let me explain why. Let me explain why, Mr. Speaker. Let me explain why. Because in fact, the tactics deployed from the very beginning were to delay until after she had served 12 months in the employment of the agency, which is precisely what had happened, Mr. Speaker. Says, actually, it's because of the tactics that I deployed in the case that Mrs. Hernandez ultimately won. Now, Mr. Speaker, there is a huge distinction between a lawyer that is defending her client and effectively defends her client to the best of their ability and on instructions does X, Y, and Z, and a political campaign that was mounted by the honourable gentleman opposite, Mr. Speaker. That's the difference. I mean, I do not condemn either Mr. Picardo, the Honourable, the Chief Minister. I do not condemn the Father of the House for representing Mrs. Hernandez. What I condemn them for, Mr. Speaker, is for actually using this particular case as a crusade for political purposes in order to undermine the Social Services Agency, in order to undermine the Dr. Giraldi home, and in order to undermine the government of the day. That is something that I would never have done, because I refuse to cross that line between acting for somebody and giving legal advice and legal representation and effectively using that individual as a political pawn, which is what has happened in this particular case, Mr. Speaker. And that is the point that I make. And therefore, to the extent that he thinks in his own mind, in his own Walter Mitty mind, Mr. Speaker, that some letter that I wrote in October of 2005 is some knockout blow, he's completely and utterly mistaken, Mr. Speaker. Because I was acting as a lawyer, Mr. Speaker. The problem here is that they have transgressed the boundaries between legal representation and making a political pawn and a political tool out of this particular case, and indeed out of Mrs. Hernandez. But returning to the misrepresentations made by the Honourable the Chief Minister during the course of his own intervention. Mr. Speaker, he said that I had made a complaint to the Bar Council in order to get him disbarred. Mr. Speaker, what world does he live in? Where is the evidence of any complaint that I have made against the Honourable Gentleman to the Bar Council or the Administrative and Disciplinary Tribunal Committee to get him disbarred? Neither have I made a complaint against him either a day before his father died, and I'm really sorry about that, or indeed have I represented anybody in the making of that complaint, Mr. Speaker. But look, yes, my brother made a complaint against the Honourable Gentleman. He made a complaint against the Honourable Gentleman because at a time when Hassan's was acting against the Vox newspaper, the editor of the Vox at the time came out during the course of those defamation proceedings saying that the Honourable Gentleman had provided advice to the Vox newspaper and he was a partner of Hassan's. In other words, Mr. Speaker, my brother was being represented in defamation proceedings against the Vox by Hassan's, and the Honourable Gentleman, who was a partner in Hassan's, was advising the Vox newspaper, the defendants, in that same case. So talk about conflicts of interest, and talk about acting against the interests of your client, Mr. Speaker. Mr. Speaker, and he has the audacity to refer to a letter that I wrote acting in my capacity as a lawyer, Mr. Speaker, when he was providing advice to the defendants, to the opponents of a... Mr.
Speaker, the point of order is very simple. He has said I was providing advice. Mr. Speaker, that is not the case. The complaint was made, and yes, it is, Mr. Speaker, because it relates to facts which the Honourable Gentleman is asserting. I did not provide the advice. The Admissions and Disciplinary Committee dismissed the complaint. Yes, it did. You better check your records. Dismissed the complaint, Mr. Speaker. And he therefore needs to make himself responsible for what he's saying in this House. The way that he is describing everything is entirely untrue, Mr. Speaker, and if necessary, I will move a motion to the effect that he has misled the House again. He has to make himself responsible for what he's saying in this House. He has to look at what I said and defend what I said and not what he says I said, and go back and look at those files, because I have today, Mr. Speaker, and what he is saying is untrue.
That is not a point of order. That is not a point of order.
I have gone on, But the original point of order, Mr. Speaker, is that it is wrong for him to say that I was representing those people contrary to my obligations, and in fact the complaint that was made was dismissed. I've then gone on, but that is the point of order.
Mr. Speaker, the reality of the situation was that my brother took proceedings against, and he's brought my brother into the session today, not me. He is the one that's mentioned my brother, and he has brought him in. He's not here to defend himself. So I have to correct, Mr. Speaker, I have to correct the record which he wrongly said. Mr. Speaker, my brother took proceedings in defamation against the Vox newspaper, and the editor of the Vox newspaper in writing said that the honourable member opposite, the Chief Minister, had advised him as editor of the Vox. That was the evidence that was provided in the context of the defamation action, Mr. Speaker. He can bring whatever motion he wants to bring, Mr. Speaker. That is what happened, Mr. Speaker. And let me tell him another thing, that the reason why that complaint by my brother to the Admissions and Disciplinary Committee was dismissed, I think it was withdrawn, Mr. Speaker, is because my brother actually extended the hand of friendship that he has spat on today, Mr. Speaker, during the course of his intervention, and withdrew it, Mr. Speaker. He withdrew the complaint against the honourable gentleman because, quite frankly, he was a partner of Hassan's, my brother Nigel was a partner of Hassan's, and everybody wanted to move on. He extended the hand of friendship, and Mr. Speaker, he has spat upon it today, Mr. Speaker. But what I will not allow, Mr. Speaker, is for him to misrepresent the record, Mr. Speaker. Mr. Speaker. But Mr. Speaker, let me return to the smoke screens, contradictions, and duality. And look, I've also received a text from my brother Nigel relating to interceptions of communications, but I'm not going to go there. I really don't, no, because I don't want to go there. But I'm going to go, I am going to proceed to talk about smoke screens, contradictions, and dualities, Mr. Speaker. Mr. Speaker, the Honourable the Father of the House said, what political advantage could there be in wanting to get to the truth by conducting an inquiry? That's what he said. And then, Mr. Speaker, in the same speech, he took almost an hour, Mr. Speaker, making a mockery of the very inquiry he sought and indeed orchestrated, Mr. Speaker. He said, we wanted to get to the truth, Mr. Speaker. That's why we conducted the inquiry. And then when the inquiry produces results, Mr. Speaker, that they are not happy with, he then spends an hour making an absolute mockery of the inquiry that they themselves instigated. Mr. Speaker, and making too a mockery of Sir Jonathan Parker, Mr. Speaker, who they have, during the course of tonight, both the Father of the House and indeed the Honourable the Chief Minister, who has followed the lead of the Father of the House, referred to him really disrespectfully, Mr. Speaker, as Chairman Mao and Chairman Parker. Mr. Speaker, they appointed Jonathan Parker, one of the most eminent lawyers of his time, Mr. Speaker, and I have to say that I was thoroughly disgusted with the way that they have sought, Mr. Speaker, to denigrate an eminent judge, Mr. Speaker, and also an eminent judge in the conduct of an inquiry that they themselves instigated. And Mr. Speaker, when the Honourable the Father of the House was speaking in response to my motion, I had made a note to ask the Chief Minister to apologise on behalf of the Father of the House for the comments that he had made about Sir Jonathan Parker, and indeed about the inquiry itself, because really what he was saying is, yes, there was this inquiry, but really it was either a biased inquiry or it didn't do its job properly, it's come to a wrong conclusion, and it didn't listen to me, and it should have listened to me, and he should have concluded this was all a big conspiracy on the part of the GSD government. And Mr. Speaker, I was going to ask him to apologise on behalf of the Father of the House, but the Chief Minister started his intervention by saying, I want to congratulate the Father of the House, his passionate and masterful intervention. His forensic analysis was superb. So, Mr. Speaker, here we have the Chief Minister of Gibraltar, who calls an inquiry, who asks Sir Jonathan Parker to head that inquiry, and then during the course of this parliamentary debate proceeds to absolutely trash Sir Jonathan Parker's conclusions and Sir Jonathan's the conduct of the inquiry. Well, Mr. Speaker, I mean, I have to say that if there is any contradiction and duality, Mr. Speaker, it's in the conduct of the honourable gentleman and the way that they have sought to proceed today. And let me remind Mr. Speaker, the honourable, the Leader of the House, what he actually said when the report was first published. And we'll see, and we will then see, Mr. Speaker, who is contradicting himself and where the duality lies, Mr. Speaker. When the report was received, he said this: I am grateful also to the legal team that supported Sir Jonathan. Well, I am very grateful to the Right Honourable Sir Jonathan Parker for this exhaustive and comprehensive report into various allegations of malpractice at the Dr. Giraldi home, which concerned the government greatly and which led to the establishment by me of this inquiry. So he's congratulating Sir Jonathan Parker for the exhaustive and comprehensive report. He then says, in the very short time available to me since I received the report, I have noted with satisfaction that the report concludes that any instances of mismanagement, misconduct, and malpractice at the home were infrequent and at the lower end of the scale of what this type of behaviour. That was the issue that most concerned my government, Mr. Speaker. So going from appointing Sir Jonathan Parker, from congratulating Sir Jonathan Parker for his very exhaustive and comprehensive report, and from saying he's really glad that all those nasty allegations of misconduct, all the ones that I had outlined in my intervention, the sexual abuse and all the rest of it, the torture, etc. I'm so glad that none of that was proved unfounded. And he's also glad that really what was found as true, or found by the tribunal, was malpractice at the lower end of the scale. Well, Mr. Speaker, that certainly does not justify the trashing, the systematic trashing of this report that has taken place over 3 or 4 hours by the members opposite, in particular the Father of the House, but of course now aided and abetted, a phrase that he doesn't like me to use, but that is precisely what has happened, by the Honourable the Leader of the House and Chief Minister. Mr. Speaker, talking about dualities, the Honourable the Father of the House said that if a Spanish journalist doesn't come here, well, the Spanish journalist comes here, I do not have to go there, he says. I did not go to Spain to give an interview in a Spanish TV program. The Spanish producers of the program came to me. Mr. Speaker, I don't know what kind of a defense he was setting up, but Mr. Speaker, even he, in his warped reality of what is damaging to Gibraltar is not damaging to Gibraltar, would have realized, Mr. Speaker, that any interview that he gave here in Gibraltar was going to be shown in a program in Spain. Or did he really think, Mr. Speaker, that the producers of the Espejo Público were going to come to Gibraltar to interview the honourable gentleman, but then not air his comments in a program in Spain, Mr. Speaker? Mr. Speaker, what a poor excuse. What a poor excuse. But Mr. Speaker, he then, in defense of the comments that he made in the Espejo Público, he said, well, actually, what the Espejo Público was saying was absolutely true. That's what he said, repeated by the Honourable, the Chief Minister. The Espejo Público said that there was fear of the administration, there was fear of the GSD, and therefore that's why these allegations people were not coming out with these allegations publicly. And he also said that the allegations, certainly one of the allegations was true, but indeed, in his comment that there was a cover-up here in Gibraltar, Mr. Speaker, what he is doing, and does he not realize that what he is doing, he's giving vent to the allegations. He is giving credibility to the allegations, Mr. Speaker. So what has happened is that instead of apologizing for comments that he has made to the Espejo Público, which were not true, Mr. Speaker, because the inquiry has found that the allegations were unfounded, what he has done yet again, Mr. Speaker, is give vent to those allegations, give credibility to those allegations by actually saying, well, the allegations were true and there was a climate of fear in Gibraltar, and that's why people didn't want to come out publicly and say so. But he was brave enough to say so. Well, Mr. Speaker, it is a shameful episode. It's a shameful episode for him, Mr. Speaker. He who fancies himself, Mr. Speaker, as a defender of Gibraltar and the defender of Gibraltar against anything that is Spanish. For him in particular, to have given an interview on Spanish television, because that is what it was, an interview on Spanish television, effectively denigrating staff and the institutions of the institution that is the Dr. Giraldi home, was shameful to say the least, Mr. Speaker. But Mr. Speaker, Mr. Speaker, I hope that Mr. Speaker is alert that these point of orders don't turn into replies.
Mr. Speaker, the honourable member opposite has accused me of saying something to the guy that came to interview me, which is what I've said. I've read the sentence, and the sentence says, if the government says that these are all made up, why doesn't it go ahead and do the investigation? I said, the only thing I said to the Spanish interviewer is, this is what I've asked them to in Parliament. That's all I've said. I've not said the allegations are true, and I haven't accused anybody of anything, and I've read it to him.
Let me make one thing clear to honourable members. To rise on a point of order, to correct, to answer something that is being said, that is not a point of order. That is not a point of order. There is a rule about clarification, which honourable members should look at, but that is not a point of order. There has been no transgression of any of the standing orders by anything that the leader of the opposition has said. Now, what the Honourable Mr. Bossano is trying to do is to reply to what, well, look, he can ask the leader of the opposition, would he give way? And that is the correct procedure.
I'm rising on a point of order because the honourable member opposite has attributed words to me which I have not uttered, in the knowledge that I've already given him the text, the transcript. I've read out to him what I've said, and he's quoted me as saying something that is not true. And that is the point of order, because members are supposed to be able to prove that what they're saying is true, and he cannot, because I've got the transcript and he hasn't.
Well, Mr. Speaker, I have sat here very patiently, listened to a lot of allegations being thrown my way, a lot of points being thrown my way, and I have sat here very patiently.
I direct the attention of honourable members to 45(8), subparagraph 8. A member who has spoken to a question proposed to the Parliament may again be heard, if the Speaker so permits, to explain some part of his speech which has been misunderstood. But when so speaking, he shall not introduce any new matter. Some part which has been misunderstood. Other than that, the correct procedure is to ask the person holding the floor to give way.
Mr. Speaker, I have not misunderstood what he has said. I have not misunderstood what he has said at all. Mr. Speaker, he tries to recharacterize and to redescribe to his own benefit what he said in that program. But Mr. Speaker, he has just now proved it. He has said that what he said was, if the allegation is not true, why doesn't the government investigate it? What's that? Mr. Speaker, but doesn't he realize that by saying if the allegation is not true, why doesn't the government investigate it, that he's actually giving vent to the allegations? He's adding credibility to the allegations, Mr. Speaker. Of course you are, Mr. Speaker. If the honourable gentleman says, and look, you know, I have to say that one of the biggest respects that I've always held him in high esteem on this, if nothing else, that he has always stood up and he has said, this is what I said, this is what I meant, and he hasn't cared. But Mr. Speaker, now what he is doing is he is ducking and diving, Mr. Speaker, with the best of lawyers, Mr. Speaker, ducking and diving with the best of us, Mr. Speaker, because really what he's reminding me is of a young lawyer in front of a tribunal where a judge says, well, hang on a minute, but you've said this. I said, well, no, because this and that and the other. Mr. Speaker, he says, if the allegation is not true, why doesn't the government investigate it? Well, look, what he's really saying to everybody that cares to listen to the program is, I think that the allegations are true, and that's why the government is not investigating it. Mr. Speaker, that's the reality, and that is the point that I make, and it's a perfectly legitimate point for me to make, Mr. Speaker. That is my interpretation of what he has said. Now, Mr. Speaker.
The actual text goes much further, of course, than what the Leader of the Opposition has said. Yes. You know, the actual text in Spanish, shall I read it out? Would he like me to read it out? In English? I translate? No, I don't. No? Well, it goes further. It goes further than what the Leader of the Opposition has said just now. The point that Mr. Bossano read out, what he read out, goes further than what you are paraphrasing it. You are paraphrasing it.
No, Mr. Speaker. I have just repeated back his paraphrasing of that. He has stood up. In fact, he has agreed with me across the floor of the House. His paraphrasing, he said, yes, that's what I said. What he has said is, in paraphrase, if the allegation is not true, this is what he said, if the allegation is not true, why doesn't the government investigate it? That's what he has said, Mr. Speaker. And what I'm saying is, absolutely, that's exactly how I understood it. And that is giving vent to the allegations. Why? Because really what he is saying is, I believe those allegations are true. What is happening here is that the government is seeking to hide, to suppress truthful allegations. That is a reasonable interpretation to his words, Mr. Speaker. And what I am saying is that he is ducking and diving with the best of lawyers, Mr. Speaker, the breed that he holds in such low esteem. But Mr. Speaker, he then said, also said, well, have an independent investigation, put your money where your mouth is and investigate. But does he understand, Mr. Speaker, and haven't I been able to take him to the relevant passages from the report of Sir Jonathan Parker that says precisely that? He accepts that we did, or the GSD government and the Social Services Agency did actually investigate, Mr. Speaker, these allegations. The ones that were serious were investigated. The RGP investigated the allegations. And the Attorney General also, Mr. Speaker, concluded, at least on some of the most serious allegations, that there was no case to answer, Mr. Speaker. Now, the problem here is not that we refuse to go to an independent or launch into an independent inquiry. The problem here is that the gentlemen opposite were not prepared to accept the word of the Social Services Agency that said that they had investigated the allegations, the words of the Royal Gibraltar Police that said that they had investigated the allegation, and the word of the Attorney General, not to speak of the backbencher when he was Chief Minister of Gibraltar, Mr. Speaker. Of course there was an investigation. And Sir Jonathan Parker, Mr. Speaker, accepts that there was an investigation. Mr. Speaker, the Honourable the Father of the House also said that this was Joanna Hernandez on her own. This was Joanna Hernandez on her own against everybody else. Well, actually, no. It wasn't Joanna Hernandez on her own. It was Joanna Hernandez with members opposite, Mr. Speaker, in the political campaign and the intense political campaign that I described during the course of my intervention. Mr. Speaker, then he spoke about whistleblowers, Mr. Speaker, and whistleblowers legislation. Well, Mr. Speaker, look, talking about whistleblowers and heeding the calls of whistleblowers, where is the investigation about the 35 trainees against Joanna Hernandez, which was an investigation?
That is new material. You are introducing new material now. You are not allowed to do so when you exercise your right to reply.
Mr. Speaker, Mr. Speaker, he then also said that Joanna Hernandez was not here to defend herself. Well, Mr. Speaker, neither have been the individuals that he has spoken about, including members of my family today, 2 members of my family, in fact, 3 members of my family, 2 brothers and a father that have been mentioned here today.
May I ask the Honourable Leader of the Opposition, from a personal point of view, is he still sore about what I said about his father?
Speaker, I am not responding to the Honourable
You are
Speaker.
responding to me because I was the
No,
one...
I'm responding to them.
No, they didn't.
Yes, they did. They did, Mr. Speaker. They mentioned my father.
Well, I'm okay, fine.
Mr. Speaker, I am not so... Mr. Speaker, believe me that I have, after many years of being in politics, the hide and the thickness of a rhinoceros, Mr. Speaker. And I have to say that. I have to say that. Partly it has to be said, Mr. Speaker, during my early years, not now that I can defend myself in this House, partly the political beatings that the Honourable the Father of the House gave me all those years ago. That's made me develop a very thick skin. Mr. Speaker, nothing to do with Mr. Speaker. What we have is a situation where and this is the hypocrisy, the contradictions, the duality, Mr. Speaker. On the one hand, they say, but Joanna Hernandez is not here to defend herself. But of course, my father, whom they mentioned, the Honourable the Chief Minister mentioned him from a sedentary position, well, he is here to defend himself. My brother Nigel, oh, he is here to defend himself. My brother Michael, oh, he is here to defend himself. Well, Mr. Speaker, I mean, let's have an element of consistency, Mr. Speaker, of consistency. There's another point that I was very surprised that the Honourable Gentleman made, Mr. Speaker, because he even went as far, Mr. Speaker, as mentioning one of the service users by name. By name, Mr. Speaker, in this House. My understanding of the rules of the House, Mr. Speaker, is that one shouldn't mention people by name who are not here in this House. Well, he's not only mentioned, well, Mr. Speaker, Joanna is part of the motion, Mr. Speaker. What does a service user, Mr. Speaker, have to do with this? How on earth does he justify, Mr. Speaker, a resident of the Dr. Giraldi home being mentioned by name during the course of his own intervention? I didn't stand up and raise a point of order. Nobody cut the Honourable the Father of the House short, but I thought it was absolutely scandalous that he should do so. Mr. Speaker, the Honourable the Father of the House also mentions that my brother Nigel, my brother Michael, that they closed down the Vox. Oh my God, that's so terrible, terrible. That beacon of democracy, the Vox, being closed down by the two Feetham brothers. Well, Mr. Speaker, what he doesn't tell this House is that my brother Michael had to sue the Vox for defamation, and that there is an order of the court, an order of the Supreme Court, and I hope that he accepts that, and that we don't have criticisms of the Supreme Court in exactly the same way as if we've had criticisms of Sir Jonathan Parker and his report. There is an order of the court actually holding the Vox and certain individuals guilty of defamation, Mr. Speaker. Well, look, if they've been guilty of defamation, is the Honourable Gentleman entitled, Mr. Speaker, after there has been a case in the Supreme Court of which an individual who is not here to defend himself has been found to be defamed, is he entitled, Mr. Speaker, to then go behind the order of defamation and say, oh, because there's this witness statement and that and that and the other? Mr. Speaker, nobody intervened. Nobody said, well, hang on a minute, I think that you're out of order. No, nobody intervened. But Mr. Speaker, he was out of order. He was out of order. Because I have never come across a situation, Mr. Speaker, where a private citizen takes a newspaper and certain other individuals making allegations to court. There's an order of the Supreme Court in favour of the claimant saying, yes, you have been defamed, and the Honourable and members of Parliament come to this House and basically start using parliamentary privilege, Mr. Speaker, parliamentary privilege, to try and raise again the allegations which a court has found to be defamatory. Well, let him make those allegations outside this House, Mr. Speaker, and let's see what actions my brothers take against him, Mr. Speaker. Well, he can do it, but don't do it because it is cowardly, Mr. Speaker. Mr. Speaker, it's the third one.
Mr. Speaker,
What's
it is a
standing
breach
rule?
of the rules of the House to challenge somebody to say something outside the House, because it's a breach of the privileges to challenge somebody to say something outside of the House.
The Chief Minister is correct, and I can vouch for that, because that precisely happened to me when I was sitting there, and the Honourable Speaker, Major Robert Pelissa, ruled in my favour, exactly the same. You cannot challenge a member to, it is a breach of privilege to challenge a member to say something outside. There is a ruling from Mr. Speaker Pelissa in that respect.
Mr. Speaker, of course, if there is a ruling about challenging the Honourable Gentleman making the same allegations cloaked in parliamentary privilege outside this House, where he is not going to be cloaked in parliamentary privilege. Look, he's not defaming me. It's not me that's been defamed, Mr. Speaker. If there is a ruling, well, I accept that there is a ruling, Mr. Speaker. But the point that I'm making is in a different way, and it's this, that I don't think it is right for a member of Parliament, but again, I mean, I will sit down and allow Mr. Speaker, if he thinks otherwise, I will allow Mr. Speaker to intervene again in relation to this. I don't think, Mr. Speaker, Mr. Speaker, I do not believe that it is right for a member of this Parliament to go behind a defamatory judgment, a finding of the court, in this House, seeking to undermine that order of the court, when if you cloaked in parliamentary privilege, when knowing that if he made the allegation outside, he wouldn't be cloaked by parliamentary privilege and he would be subject to a defamation action. Because, Mr. Speaker, the reality of the situation is this. But let's be clear that if an allegation that has already been determined by the court is repeated outside this House, it's defamatory, Mr. Speaker. That is the point that I am making.
Yeah, but the point is this: we are not outside this House; we are within this House, and here, honourable members are protected. They can say whatever they want, and they cannot be sued for defamation. Right? Their freedom of speech is protected. Okay? So honourable members here can say whatever they want. Outside, it's another matter. All right? But you cannot challenge a member of Parliament to repeat outside something that he has said here in the House, challenge him in order that he can then be sued for defamation or whatever. That is the, it's a parliamentary position of privilege, going back to the foundation and the battle for Parliament against King Charles I. Going back, therefore, to the, what century are we talking about? 17th century. That is a sacred right of all honourable members.
Mr. Speaker, for Mr. Speaker to compare, I have to say, he's intervened now a number of times in this debate, but for Mr. Speaker to compare a member of the House coming to this House and repeating an allegation that has already been determined by the Supreme Court. May I be allowed, Mr. Speaker, without interruption from Mr. Speaker? I will sit down if Mr. Speaker wants to. Thank you very much, Mr. Speaker. For a member of Parliament to come to this House and effectively abuse a privilege by repeating allegations that have already been determined by a court in the Supreme Court, I don't think is right, nor is it, hang on a minute, Mr. Speaker, may I please finish? If you want, I can sit down. Okay. May I? I mean, I just haven't finished the point. Mr. Speaker, I haven't finished the point. Nor is it comparable in the most imaginative mind, Mr. Speaker, to defending privilege in Charles V's time, Mr. Speaker. It just cannot be the same, Mr. Speaker. It cannot be the same. If a lowly carer, Mr. Speaker, has to sue a newspaper for defamation and gets an order against a newspaper and those making allegations, an order of the court that he has been defamed, it cannot be right, Mr. Speaker, for then somebody, an MP, cloaked with parliamentary privilege, to come to this House and repeat those allegations. It just cannot, Mr. Speaker, and no quoting of rules is going to move me from that. But of course, your ruling, Mr. Speaker, is stands. I accept it, but I have to say that I do not agree with the logic in the least, Mr. Speaker.
I am now going to. The honourable member, or any honourable member, has a perfect right to say that that is not right. That in his view, it is not right for an honourable, for another member to abuse, if you like, the right of privilege in the terms in which has happened this evening, in respect of that the court ruling of defamation against his brother. That is perfectly clearly understood. Now, however, I can tell the honourable member that when I was the leader of the opposition, someone from outside Parliament, I received a letter from a member of the legal profession representing the Transport and General Workers Union, challenging me to say outside the House what I had said here. I showed the letter to the then Speaker, who hit the roof and who made a ruling in that respect. It was an abuse of contempt of the right of privilege. Now, so I am not going to stop the Honourable Leader of the Opposition from saying that he doesn't agree that it is right for Mr. Bolzano to have said what he has. Fine. Right? He's perfectly entitled to say that. Okay? Perfectly entitled.
Mr. Speaker, it's a completely different situation, and I understand. No, Mr. Speaker, I'm on my feet and I'm not giving way. Mr. Speaker, I am not giving way. And Mr. Speaker, this has been peppered, my intervention has been peppered by interventions, Mr. Speaker, in fairness, from the Speaker's chair, in good faith, I accept that, and also from the other side.
I would like to see whether anybody could, in Gibraltar, could sit in this chair, as I have done since 5 o'clock, and conduct the proceedings of the House better than I have done. For the first two motions, I had no problem at all. I didn't have to intervene. I've only had to intervene when matters have got hot under the collar in the last hour. Then I have had to intervene because honourable members have been going too far, right, in breaking the rules of debate. Otherwise, I would not intervene. Now, it is 2 o'clock in the morning. I think we are all tired, right? We're all very, very tired, and it is very difficult. And honourable members have an advantage over me. They can go inside and out whenever they want. They can switch off completely and not pay any attention to what is going on. I have to be here listening to every word, paying very close attention. And that is the difficult job which any speaker has, and in particular here in the present circumstances. Okay? So, I am not infallible. I may make mistakes, but what I am is impartial. I try to be fair to both sides, and I only intervene if I think that I have to. Otherwise, I don't.
So, Mr. Speaker, rising on behalf of this side of the House, dealing with the point of order which the Honourable Gentleman has been dealing with you, Mr. Speaker, we entirely accept that the rationale of not being able to challenge somebody to repeat something outside the House, the instance which you referred to, is exactly because, and this is what the rule is about, people have sometimes obtained rulings outside the House, and I'm not commenting on the current issue, rulings or statements, or they have obtained judgments because of, for example, higher economic power than the person who may have said something. And the Parliament is the place where that person's representative can come and make the statement if they still believe it to be true and defend the truth of that statement. That's what the rule is all about, and therefore, Mr. Speaker, we entirely agree with your ruling and would ask the Honourable Member to please, in order to ensure that the debate can continue in the way that you've indicated the earlier debates were held, to stick to the issues in the motion so that we can vote on the motion and hear the Parliament's will in respect of the motion.
Mr. Speaker, there is a huge distinction, Mr. Speaker, between, and I have to say, because I think there is an important point of principle here, there's a huge distinction between the example that Mr. Speaker gave, which is somebody from the Transport and General Workers Union writing to a member saying, repeat that allegation outside, and the situation that I am addressing myself to, which is, there is a court case, there is a judgment, and then somebody, a member of Parliament, then effectively wants to go behind that judgment by and undermining it by repeating here what he could not say outside because the matter has been determined. Now that, and I believe that is abusive of the privileges of this House. Not because, and look, very often, Mr. Speaker, I may say something in this House in the course of discharging my role as Leader of the Opposition, or he may say something in this House in the course of discharging his role as a minister that technically, if it's said outside, may be defamatory. And I accept that, and that's why privilege is there, in order to encourage open debate. But what the rules are not there, what privilege is not there, in order to do, is to allow somebody to just simply say, well, there is a judgment, a defamatory judgment in favor of somebody. There is a witness statement that has been withdrawn as being false, and it's been withdrawn. But what I'm going to do is I'm going to come to this House and I'm still going to read from that witness statement, and I'm still going to try to undermine that judgment, Mr. Speaker. That, with respect, is an abuse of the proceedings of this House and the rule in relation to privilege, Mr. Speaker. Look, Mr. Speaker, I don't intend to prolong these proceedings much further. If I have, Mr. Speaker, been harsh in any words that I've spoken to, Mr. Speaker, I don't believe that I have. It's just that I feel strongly about this particular point, about that Mr. Speaker has genuinely looked at it from the perspective that in fact is the wrong perspective. If I challenged him to repeat it outside, I wasn't challenging him to repeat it outside, but if I was, I accept your ruling. My point was a completely different one, Mr. Speaker, and it's about the abuse of members of this House of parliamentary privilege. It's a privilege, Mr. Speaker. It should not be abused, Mr. Speaker. It should not be abused.
I will now put the motion. Is a division required?
To a division, yes, please.
Voted on the amendment. Now what is before the House is a substantive amended motion. Is it, all right? It's the amended motion which is now before the House.
P.J. Valvan. J.J. Vosano.
Yes.
D.J. Vocino.
No.
Pia Caruana absent. J.E. Cortez.
Yes.
N.F. Costa.
Aye.
Isabella Lul Hammond absent. D.A. Feetham.
No.
S.M. Figueres.
No.
J.J. Garcia absent. A.J. Isola. G.H. Ligudi.
Yes.
S.E. Linares.
Yes.
J.J. Neto. F.R. Picardo.
Yes.
E.J. Reyes. S.J. Sacramento.
There are 3 members absent. 9 have voted in favor of the motion. 5 have voted against. The amended motion is carried. The Honourable the Chief Minister.
Mr. Speaker, conscious of the late hour and the acrimony of the debate towards the end, but conscious also of the important issues that have been debated during the course of the afternoon, I now invite the House to adjourn sine die as we commence the period known as Holy Week and wish all members the best for this period, which will involve some holiday time and which will involve the House not sitting this month as has been agreed in other years. I now move that the House to adjourn sine die.